Hello, everybody. Hey, let's try to get a seat. It's a great day to be alive. Good afternoon, everyone. My name is John Josted, and 35 years ago, I started the first ethics seminar by introducing myself. And now I have to introduce myself. But anyway, thanks for coming, and for all of you out there in video land, I hope this works. It always seems that something doesn't work, but we have a great lineup today. We have great materials. I was reading through everything, and we can get started. Our first speaker is from Attorney Regulation. He's an assistant regulation counsel down there on the, hello? Can you give me three, please? Three. Okay. We're resending the Zoom link. Okay, my daughter told me a joke I can tell. Yeah, how can you tell a dad joke? It's very apparent. You can use it. So the priest and the minister and a rabbit were walking down the street, and they were talking about going to the blood donation center. And the priest says, well, I was just there. I'm blood type AB. And the minister says, I was just there myself. I'm A negative. And the rabbit looks up and he says, well, I'm a type O. I know it takes a while. I think that's a politically correct joke. Is Jerry? It's not? Oh. I mean, I have type O. I have type O blood, so I think I can tell it. So, Jen? Anyway, we're here. J.P. Moore, you're in the trial division of Attorney Regulation, University of Oregon, and CU Law School. Done a stretch as a DA in private practice. He's up here from the Attorney Regulation Office, and we're very lucky to have him. Please welcome him.
All right, is this working for everyone? All right, excellent. It is wonderful to be with you all today. Thank you so much for the introduction. My name is J.P. Moore, and I am in the trial division. I've been in the trial division for about 9 years now, and this is my first time presenting about this topic. And it's one that we at our office are very, very excited about, and that is the licensed legal paraprofessionals. Now, I will tell you, this is a new creation. Who has a thought about why this is particularly important? Any thoughts about that? Yes?
It's an access to justice issue.
Access to justice issue. One of the important regulatory objectives and one of the important principles that is emphasized time and time again is access to justice in Colorado. This exactly deals with that and is designed to address that and to provide access to individuals that might not otherwise be able to have it. So it is a wonderful thing, and it's something that really goes along with the importance of addressing that need that individuals have around the state of Colorado. So we're going to talk about that today. And we're going to talk about licensed legal paraprofessionals in a few different ways, but we're also going to talk about you and your role and your interactions with LLPs and how we can make this as successful as possible. So we're going to cover some of the benefits. We've talked about one, which is access to justice. But we're going to talk about the scope of what LLPs can do and also rules that govern LLPs. We'll talk about common questions that come with this program, and then also the interplay between lawyers and LLPs, and how you can be successful and how they can be successful, and as importantly as anything else, how the system can be as successful as possible for serving Colorado clients. So first of all, some background. 2023, a very new creation. It's a new legal profession. That's what LLPs are. And it's under Colorado Supreme Court rules that were designed then, and it says paralegals and other legal paraprofessionals can apply for licensure to provide certain legal services in certain types of family law matters. Now, is what they can do unlimited? Absolutely not. And we'll talk about some limitations. But there are a whole host of things that they can do. And it's important that we understand that. Now, 207.1 is the Colorado Rule of Civil Procedure that governs legal paraprofessionals, licensed legal paraprofessionals. And again, it was developed through the Colorado Supreme Court's Rule Drafting Committee. And I want to point out, and I'll mention this again through the talk today, that if you go to our website, you can find a whole lot of different questions. It's way more robust than this conversation today, but a whole lot of common questions and answers from this committee, okay, this rule drafting committee. And this committee said that there are certain things and has provided us insight about what can be done and what can't. Again, here's the rule and here's the House bill. And the focus with LLPs is on non-complex domestic relations cases. Now, is that going to mean every single case fits? Well, certainly not. Certainly not. But what we are talking about, if we have a non-complex case, perhaps one with relatively low net marital assets, that might be a really good fit. Satisfying a character and fitness evaluation. Continuing registrations are requirements, CLEs, and ethical obligations for LLPs exist and are spelled out in rules that govern them. So there's a whole host of things as far as entering this profession, but then also as you are in this profession, going to sound very familiar to other lawyers and the different things that lawyers have to do. There are these things on an ongoing basis. So a little bit more background. As we sit here right now, there are 91 LLPs in the state of Colorado who have gone through the exam, who have gone through the licensure process. Okay, 91. So that's really exciting. We're off to a great start in a short period of time. additional option instead of purely unbundled services. And I just heard the microphone get louder. Okay? So think about that. And these folks can provide benefits such as when there are conflicts with dates, with other practitioners, say in a firm and in a practice. This provides an entirely different avenue for coverage. Now, LLPs do not necessarily have to have law school or trial experience, and they don't necessarily have that, okay? And their route might be a little bit different to getting to this licensure. However, they have a ton of family law experience. And think back to when you started practicing. And think back to when others around you and other lawyers started practicing. And think about where they started practicing from in terms of that specific area. It's something that's learned. And think about the advantage that LLPs can bring and the fact that they do have this family law background and they can bring that to the table. So again, in terms of the effectiveness of the services, it really does become self-evident. So they typically have this background and this experience. A little bit more about the rule. 207.1, again, governs LLPs. And we're going to talk a little bit about what LLPs can do and a little bit about what they can't do. So they can represent clients in marital, civil union dissolutions, and legal separations, allocation of parental responsibility, establishing and enforcing and modifying child support, and other things that are on this slide. So there's a whole host of things that they do and they'll be able to advise those clients. In general, they are able to appear in hearings, but that comes with limitations. They can be referred to as counsel. They are professionals, as long as the record is clear and communication happens that LLPs are that this individual is an LLP. Okay, that needs to be made clear through the process. But they can be referred to as counsel. Now, what about the scope of representation? It's important to communicate for LLPs and for firms that are working with LLPs to communicate with the client about limitations. And one place that this communication can happen is by putting it in the fee agreement. And for all of you, I think you can appreciate that what goes in the fee agreement is the beginning of very effective communication between the attorney, between the firm, and the client. So putting those limitations and what we're going to talk about in the next few slides in that fee agreement is a really critical step for the practice to think about, for the firm to think about, for the lawyer to think about, and for the LLP to think about.
JP, stay up on the mic.
Stay up on the mic? Okay, got it. Is this better?
Yep.
We good? Okay, awesome. All right, so what are some of the things that are within the scope? So the slide's going to lay out things that are within the scope and then on things that are outside the scope. So in addition to entering appearance and filing pleadings and other documents in a court proceeding, which an LLP can do, an LLP is allowed to represent clients in court hearings. So we start with that baseline. They can do that. They are able to speak in court. They are able to explain their client's position and tender stipulated exhibits. LLPs are not allowed, however, to examine or cross-examine witnesses. So if a hearing is going to take that form, there's going to be a point in which the LLP needs to stop in that process. LLPs may be restricted in their representation when a court has determined that an expert report or testimony is required, and specifically to value an asset or determine income due to inherent complexity of the asset or income at issue. So this issue of expert, I want to pause here because we're going to talk about this a little bit more. If there's going to be an expert involved for these reasons, and that becomes known, then it does create complexities. And there are some issues that need to be worked through. Now I'm going to preview now something I'm going to talk about in a moment. It doesn't mean withdrawal is necessary at that point. That's not what it means, but there are some things that need to be considered and some steps that need to be taken. Now, what about things that are outside the scope? So things like registration of foreign orders, motions for orders regarding punitive contempt, citations under CRCP 107, that's outside the scope. Matters involving an allegation of common law marriage, in which the other party disputes the existence of common law marriage or the date when it occurred, that's precluded. Matters involving disputed parentage, when there are more than two parents or alleged parents asserting or denying legal parentage, that's outside the scope. Okay? Matters in which a non-parent's request for APR is contested by at least one person, again, outside the scope, as is preparation of or litigation regarding pre or post-nuptial agreements. That's outside the scope. So these are things that are outside the scope. And there's still other things, okay? Matters in which a party is a beneficiary of a trust and information about the trust will be relevant to the resolution of the matter. When that's the issue, that's outside the scope, okay? What if the party intends to contest jurisdiction of the court over any issue in the matter? That's outside the scope, okay? As is the preparation by the LLP of QDROs, QDROs, okay, which is qualified domestic relations orders. That's outside the scope as well, as are other documents allocating retirement assets that are not liquid at the time of the matter. Okay, that's outside the scope. And then the preparation by the LLP of documents needed to effectuate the sale or distribution of assets of a business entity or commercial property, outside the scope. Matters in which expert report or testimony is required for this purpose, and again, valuing an asset or determining income due to the inherent complexity of the asset or income, that's outside the scope. We're going to come back to number 11 right there. And then issues related to, but directly affecting a matter which falls within the LLP's scope of practice, okay? And these things that are listed on the slide right here, these are outside the scope as well. So these collateral issues. So there's a number of things that are outside the scope. And I use these slides, and I wanted to bring these slides to your attention because there are certainly limitations. Okay, and I want to be real about that. And it's important for LLPs and the firms to be aware of those going into these relationships. And part of this is managing the expectations of the client. But part of it is also communicating with the opposing counsel and communicating with the court. Okay, because part of this is access to justice. Part of this is the effective administration of justice. So this communication is really key. There are some common questions and answers from the LLP committee, and you can find those at our website. And this is coloradolegalregulation.com. And we recently changed our website. So you can find these questions and you can find these answers from the committee on this website. Okay, so definitely take a look if you are going to go into these relationships and if you're going to be working with LLPs in your practice, or if you're going to be working as opposing counsel or working in a case with an LLP. So what if witness testimony is needed? What about that? What happens then? Well, again, there's limitations on the scope of practice. And within these limitations, the LLP cannot do direct or cross-examination. But the LLP, one of those things, one of those steps that might be taken is to have the LLP, one thing they can do is to help the pro se party prepare for that process. That's one way through this, okay, is to help the party prepare for that part of the case. Okay, so the LLP can do that. Now, what about discovery tools? Those of you that do civil practice, those of you that do domestic practice, family law, different areas that have these discovery tools. It is okay for an LLP to do written discovery. An LLP can prepare written discovery. Depositions, on the other hand, another discovery tool, are outside the scope. But an LLP may be able to defend one as long as they are not taking testimony. And defending a deposition, for example, there is a difference. If you're talking about taking the deposition, it's talking about questions and answers of the particular witness. Defending it is a little bit different. So the witness or the LLP may be able to do that, but cannot take the deposition. Now, we talked about experts in terms of the limitations, okay? So 207.1 subsection F, subsection Roman numeral 11 only applies when the specialized knowledge of an expert about an asset's value or an individual's income is being provided through an expert report or testimony, and that it is required due to the inherent complexity of the issue. So there's limitations as to when this becomes an issue, when this issue becomes ripe. But if that type of situation arises where the expert testimony is needed, then an LLP is going to have limitations on them. So here's an example. Okay, here's an example of that limitation. Okay, if the valuation or income could be argued based on publicly available information, an expert report may not be required, if not, will not be required. So you have the example of the expert, but you also have, there could be a workaround. In that situation, where it is not required, where the expert testimony or the expert report is not required, and an LLP could handle the case, including any expert report that the parties jointly or separately elect to obtain. Additionally, an owner could testify to the value of property or business assets they own. And so an expert report or testimony in that situation where the owner could testify to it may not be necessary at all. Okay? So if that owner's testimony is likely to be sufficient to establish this factual information, then we might not be confronted with the limitation. But it's important to think about what is necessary in that given case in deciding whether an LLP is something that an LLP is going to be, you're going to foresee limitations. Okay, so what is going to be required? So here's a scenario for all of you to think about. What happens if an expert is called by the other side or is needed by that side? Okay, what happens? So it's not the LLP that needs, or the LLP's party that needs to call the expert. But what about the other side? And the other side communicates that they're going to call an expert. Well, in that situation, likely one of two things in general would need to happen. Another practitioner would need to come in. That would be one possibility. So another practitioner, say from the firm, another lawyer, etc., comes in, handles that part of the matter. Or the client would need to handle it themselves. So one of those two situations would need to happen if you find yourself in that situation with the expert. But as I mentioned before, that type of situation would not require the LLP to withdraw from the representation. So the LLP wouldn't need to withdraw, but there would need to be one of those two pathways that would need to occur. So the party being represented by the LLP could ask the court to determine whether or not the other side's expert is needed for the purposes of 207.1. And this goes back to that prior slide. And that is this. Is it the type of testimony that could be handled through other evidence that does not require expert testimony? So that's one of those possible workarounds, depending on the facts of the particular case. But if that expert testimony is going to be necessary for that reason, then there could be limitations on what the LLP is going to be able to do. Now, what about making objections? What about making objections? LLPs are allowed to go into court. LLPs are allowed to make statements and arguments in court. And these arguments need to be made with good faith, these arguments can include good faith objections within their competency. And this is the part of 207.1 that speaks about this. These objections could include those arguments that are supported by the Colorado Rules of Evidence or obligations of a party under the Colorado Rules of Civil Procedure. Okay? So these things are okay. These things are within the scope. What about preparing a witness? Well, we've seen the limitations in terms of examinations and in terms of experts. Preparing a witness is likely okay for an LLP to do. And the process of preparing a client for a hearing is a critical part of representing a client in litigation, which I think we all can agree with. that preparation is key, and it generally falls within this part of 207.1. So the preparation is likely going to be okay. What about making an offer of proof? Yes, an LLP can help a client or can prepare their client to make an offer of proof of a witness's testimony for the client to read in court. So behind the scenes, as part of this preparation, the LLP can be involved, help the witness or help the client craft that. However, the LLP cannot directly make an offer of proof to the court. LLPs are allowed to make statements and arguments in court other than examining a witness. Okay, so again, we see like with experts, there is that limitation on what they can do. So the behind the scenes, the helping the client, yes. As far as making the actual offer of proof, there is that limitation once again. Okay? And again, you can look at the rules, 207.1. I am covering a few things today, but there's plenty of things within the rule to be aware of. All right, what about using different forms? Okay, must they be JDF forms? Well, within the questions and answers from the committee, if it is otherwise generally accepted or court approved, then it will likely be acceptable for an LLP to use that document. So that's likely going to be okay. Okay, so the question there is it generally accepted or court approved in that jurisdiction, in the state of Colorado? And that's important to consider in thinking about the forms and what the LLP can be involved with. Importantly, the LLP can help a client settle a matter, which goes back to the idea of access to justice. It's a pretty critical part of this process, and the LLP can play an important part in that process, an important part in working with the client and working towards the effective administration of justice. So yes, they can do that. So let's shift our attention now and let's think about opposing counsel. Okay, and let's think about the situation where the lawyer interacts with an opposing LLP. What does that look like? And what are some things to be aware of and to think through? What if you're concerned about an LLP doing something that they are not allowed to do? One of the things that's outside the scope. What about that? What do you do? Do you just automatically go to the nuclear option? Do you automatically say, you know what, this is going to fail, there's no discussion, this is all over? Show of hands. How many people say let's go to the nuclear option? Audience participation, because it's right after lunch. Okay, I see no hands. All right. We have choices, and this is a more general thought for all of you, not just limited to dealing with LLPs and working with LLPs. How about working with opposing counsel? And I don't know how many of you are in litigation or how many of you are working with opposing counsel on a regular basis. But I will tell you that there are choices that are involved, and I will tell you some of these choices overlap with what we're talking about here. We do have choices on how we handle problems. And one of those choices is communication, and is in professionalism, and is in being respectful with the other side, and in recognizing that, this is a positive thing. This program and LLPs, this is a positive thing. And I will advocate to all of you to start from that premise, that there are reasons for it. Going back to the idea of administrating the access to justice and the effective administration of justice. So with that in mind, what are some choices? Okay, first of all, for your knowledge, LLPs need to follow the rules of professional conduct. And these are modeled for LLPs, these are modeled after those for licensed attorneys. For example, LLPs must comply with confidentiality rules, okay? And yes, the attorney-client privilege does apply to LLPs. LLPs must comply with conflicts rules, court conduct rules, and money handling rules, just like licensed attorneys do. So LLPs need to comply with these rules, and that is fair for the other side to assume that they will. If anyone believes that misconduct under these rules, that an LLP is engaged in misconduct under these rules, yes, as an option, that party can file a request for investigation with our office, Mr. Wilder and myself. Our office, the Office of Attorney Regulation Counsel. You can do that. An attorney can do that. Ours is a complaint-driven system, and it is permissible for lawyers, for judges, for magistrates, for opposing counsel for third parties to file complaints with our office, requests for investigation with our office. You can do that. And that includes if you are concerned about an LLP's conduct, okay? We would follow attorney discipline and disability procedural rules to review the request for investigation. And serious misconduct could result in suspension or disbarment for the LLP, just as it would for a licensed lawyer. So yes, that could happen. That is one of those options that is available. And there may be that circumstance where you determine, yes, that is exactly what I need to do in this circumstance, okay? I want to highlight some rules for you, okay? Rule 1.1 deals with competence. Rule 1.5 concerns about contingency fees, okay, for LLPs. So that's something to be aware of. 5.1, this is a rule that deals with supervision. LLPs cannot supervise lawyers. Rule 7.1 requires that LLPs disclose the limited scope of their representation to prospective clients and use licensed legal paraprofessional in an LLP firm name, okay? So it's important, and the reasoning behind 7.1 is to not mislead. In communications about lawyer services or LLP services, don't mislead. Okay, so that is true with LLPs as well. Most rules are similar to lawyer rules. Okay, comments, ethics opinions. These things, LLPs should be considering them as well, and lawyers, when working with LLPs, should be considering them as well. Some changes to the rules of professional conduct to account for the new LLPs. These were approved by the Colorado Supreme Court late in 2023. 5.3a, which also deals with supervision. That deals with supervision of non-lawyer assistants. 5.4 deals with professional independence, whether you're talking about a lawyer, whether you're talking about an LLP. Civil rules of procedure apply broadly to LLPs when acting with the scope of licensure, okay, per court rule adopted, again, late in 2023. CRCP 1B says CRCP 2 through 121 shall apply to LLPs when consistent with the scope of practice authorized by 207.1, which again is the rule we've been talking about this afternoon, dealing with LLPs and giving an overview of LLPs. Those are some things, again, rules that have been adopted by the Colorado Supreme Court. This is important to keep in mind. 5.3a, okay, this again is supervision of non-lawyer assistants. So take a look at the language of this rule, both parts of this rule, A and B. Okay, it's important to be aware of how LLPs have been included within this language. It's real important to keep that in mind. And it's important to keep in mind for the lawyer, and it's also important to keep in mind for the LLP working at a firm or working with other lawyers. Comment 1. This rule applies when a lawyer is working with an LLP in the lawyer's firm who is performing services within the scope of the LLP's licensure. Okay? And 5.3, responsibilities regarding non-lawyer assistance, there's the reference to that as well. Okay, so again, think about the interplay between lawyers and LLPs, and think about supervision in that interplay. So what about firms? What about firms that are going to work with LLPs? Some thoughts, some ideas for best practices. Have internal training for everyone about the things that we've been talking about the things on the website, the commonly answered questions. Think about training, about the LLP's scope of practice. Like with bread and butter things like diligence, like your calendaring, your tickle system, your filing system, if you're going to work with LLPs, be sure that there is training about that. Be sure there's communication about that and an understanding that everybody in the firm has. Okay? Conduct lawyer and LLP joint training about professional responsibilities, like the ones that we were just talking about under the 5 series. Have procedures in place when an LLP's matter that was within the scope at the outset may later involve out-of-scope issues or work. So laying out the scenario for you, if you're at a firm and the scenario arises about an expert, what is your firm going to do? What is the role other lawyers are going to take in stepping in, if that's what's going to happen? How does that process work? How does it work if there's going to be that testimony that's involved that we were talking about? So we talked about fee agreements earlier. Fee agreements, a key part of communication between the lawyer and the client, okay? It's important, if you're going to work with LLPs, to take a look at your fee agreement. Now, I'm going to tell you, take a look at your fee agreement yearly. Review that fee agreement. Whatever practice you're in, whether you're working with LLPs or not, reviewing your fee agreement is a good thing. You know why? Because sometimes rules change. 1.5H changed back in 2019. 1.5C changed in 2021. Rules change. It's important to be sure that your fee agreement and your firm's fee agreement is up to date and complies with those rules. As it relates to LLPs, make sure that your fee agreement is clear about what their role is and about limitations and how lawyers may need to be involved. Consider revisiting the intake procedures to evaluate whether prospective clients' matters could be placed or could be given to an LLP. And what kind of marketing do you have? If you're going to market for LLPs, is your marketing consistent with the expectations under 7.1? Now, what about interaction with LLPs on the other side? I think that you're going to find some of these principles are very, very similar to principles that you probably all keep in mind when you're working with other attorneys or you're working with other judges or magistrates or court staff or other professionals. Number one is respect. Understand, and I hope that you all take seriously the fact that being an LLP is not an automatic proposition. It's something that requires a lot of work and a lot of skill to get there. And these folks bring an experience to the table. So treating these folks with respect, I really want to encourage that. Okay? Respect as a professional. And that leads to this professionalism. You know, it's not just 1 month out of the year that's professionalism month. Professionalism is a great thing. Professionalism makes everybody's life easier and better. Okay? I have the opportunity to work with Jerry Pratt, who's sitting here in the front row, who you're going to be hearing from. And I could tell you, Jerry Pratt exemplifies professionalism. And you know what? It's a joy to work on cases with him. That professionalism matters. And your professionalism, your reputation, your credibility, whether it's with an LLP or whomever, that's something that's going to travel with you. So I would submit to all of you, it shouldn't apply differently when it comes to working with LLPs. This professionalism matters. And understanding they can play an important role in our process and an important role in the administration of justice and giving people access to justice. And as I mentioned, they bring valuable experience which can benefit their client and also the resolution of matters, okay? Which in turn benefits your client if you're in this area of practice, which in turn benefits the system as a whole. It is possible, as I mentioned, to contact OARC to file a request for investigation. And you know what? Rule 8.3 does talk about the obligations with regard to reporting. There is that rule in the rules of professional conduct. But is there room to have a conversation? Is there room to raise a concern with the other side? Remember that this is new. The LLP program is something that is very, very, very new. So are there going to be growing pains? Sure, absolutely. And so is there room to have a conversation and to make sure you understand the situation and to make sure if there is an issue that it's vetted? Maybe it's not the issue that it appears to be. Maybe there's different pathways that can be taken. But like with other practitioners, how many times in your practices is there value in having a conversation and seeing if you can work out issues at a lower, less drastic, less dramatic level? Okay. Is there room to work collaboratively? And will that ultimately help not only their client, but your client and the system as a whole? That collaboration. So much in the practice of law does involve collaboration, even if we're talking about adversarial processes. There is collaboration within this process. Based on my experience, I could tell you that that is not overly idealistic. There is room, even in the most contentious, most adversarial systems, there is room for collaboration. It doesn't mean everybody's going to agree on everything, but there can be collaboration in the process. And I will submit that is true with LLPs as well. Now, there's Rule 5.3, which is a rule that's unique to Colorado. It's not part of the model rules of professional conduct, but this deals with threatening the other side. Threatening the other side solely to gain an advantage of a civil matter. So one of the things that I'll suggest is along the way, alongside of working collaboratively with the other side and being respectful and being professional, this is something to be avoided, okay? You want to be careful about making threats. Now, does that mean somebody cannot report a concern to OARC? No, but there's a difference between reporting the concern and threatening. If you do not do this, I am going to bring disciplinary charges against you. That type of threat, ask if this, then that. Ask why that is included in the conversation that you're having, okay? And again, think about the different alternatives that we have here. This is new. And I'll tell you, folks, I think this is an exciting thing. I think this is an exciting proposition. And this is an exciting opportunity to provide access to justice, just like what we started with earlier this afternoon. Those are some thoughts I have about this. This is my contact information. I think I've got a couple of minutes. Any questions? Other than definitely take a look at our website. Definitely take a look at the questions and answers from the committee. I really appreciate being here with you. It's an honor. I hope you have a great afternoon. Thank you so much.
Thank you, JP. JP, are you seeing LLP firms that are just LLPs without attorneys?
You know, I can't speak to the structure off the top of my head. I don't know.
Okay.
So it's something, I was asked another question about the location. That's something that you can certainly contact our office about the structure that folks are in.
Okay. Thank you. All right, JP, thank you very much. Our next speaker, also from Attorney Regulation, is James Wilder, an Assistant Regulation Counsel in the intake side of things. Okay. Get a mic that you don't need to be talking to have it work, I guess. But okay.
Makes me feel like a rock star. 1, 2.
Relation Council, the intake side of things. He's a DU law grad, has an LLM, I don't know, Lüneburg, Germany.
Correct.
He
Well
speaks
said.
German, French, and Spanish.
And a little English.
Snakker de Norsk?
9.
And he has materials presenting on the unauthorized practice of law issues. Please welcome James Wilder.
Yes, thank you. It's so hard to follow JP with that excellent presentation on ULPs, and I get to go with UPLs. So we're going to talk about UPL, unbelievably powerful lasers. We're going to start with, let's see, yes, the Death Star in comparison with Starkiller Base. Death Star has gets its power from the Kyber crystal, as I understand it, the best studies said. So how do we regulate these kinds of unbelievably powerful lasers? That's with a small band of rebels that fly X-wing fighters. Now it occurs to me this might not be Comic-Con because it looks like there's a few too many Doctor Who's in the audience and not enough sandworms or anything else. But I guess this is just really my plug for I'm a Star Wars fan. Although I don't know if you knew, thank you. That even the original film was an adaptation of Akira Kurosawa's, The Hidden Fortress, which I say mostly just to sound more intelligenter than the rest, and also because that's my defense from my wife, who does not find it to be great cinema. But, and I just like adaptations. I especially when they do a modernization of them. I like the 90s Clueless movie is Jane Austen's Emma. 10 Things I Hate About You is Shakespeare's Taming of a Shrew. I even saw recently an adaptation from an old Charles Dickens short story. I'm Up at Christmas Carol. That just blew my mind. But I really like that one too. Disney put out an adaptation in 1940 of an 18th century Goethe poem called Der Zauberlehrling. And I don't know if you know which one that is. Exactly, thank you, we've got it right. The Sorcerer's Apprentice. And for those of you who do not remember the story of The Sorcerer's Apprentice, what we have is an apprentice who, after his sorcerer boss goes home, then remembers that he has some chores to do, but he knows enough to go find the sorcerer's spell book and cast some spells to help him out with it. And he knows enough to find the book, open the book, cast some spells, and it goes fine at first, and shortly turns into a whole lot of trouble. And at the end, the sorcerer has to come back and save the day and put things right, because he knows how to really read the book. He knows how those spells work, how to manage and use that power. Now, other than trying to sound more intelligenter by talking about 18th century Goethe poems, why are we talking about this? Because I want to talk about why do we prohibit UPL, the unauthorized practice of law? Because the why helps us with the what and the how. The why will lead us, and we can talk about the what and the how. And why do we prohibit it? Is it because we are all wizards and we want to keep the book safe? That is not why. We do it because that little bit of knowledge can be a dangerous thing. All right, that's why we regulate it. And I really want to emphasize that in part because I get accused more than once, and probably more than once a week, that why we regulate UPL, or what we're doing with UPL, is just to protect us lawyers. And honestly, if that's why we were doing it, we would have more than just kind of a publicity problem. There'd be antitrust issues, the Supreme Court case of North Carolina versus Dental Board from 2015 would give us other kinds of trust issues if that was the reason why we're doing it. But we do it because we're out there to protect the public, and I really want to emphasize that. Also, just because when you're calling our office, someone's reporting it to us, and this is why I said it's going to lead us to the what and the how. You'll understand how we're looking at this. What are we doing to protect the public? Because those people with just a little bit of knowledge can be dangerous. I think we all can remember that a little bit after first year law school. Everyone who thinks, I've learned to read a case. I know how to, look a few things up. I know how to open the sorcerer's book. Now I know how to help everybody. And then a few years later, you realize I didn't know anything. I mean, I was, decades in now, and I still don't know everything. You don't know how much you don't know at those early stages. So when we're talking about UPL, the first thing we need to talk about is, what is the practice of law? Because this also gets confused. I mean, I'll tell you, I have this debate even within our office sometimes. What is the practice of law? What are we talking about when we talk about the practice of law? Because we first have to determine, is it the practice of law? And then, is it authorized or not? So what is the practice of law? And it's kind of, only the Supreme Court really knows, because they define it. And one of the things we'll talk about here a little bit, because it has, although the general framework's been around now for decades, only in 2022, when the Supreme Court adopted these new UPL rules that we're going to talk about a little bit, did it actually get codified. Before that time, it was just a series of cases that defined it, and so you'd had to go look for it and do that. Obviously, those cases are still good case law. That's what the codification is based on, but it's important to realize that now we have kind of this rule that lays that out a lot clearer, hopefully for not only us, but those who are not licensed, that we can direct people to it and do that. To talk about what the practice of law is, I also want to talk about what's the difference between legal information and legal advice. And you can see this very nice definition that we have up here. This comes from the ABA. I won't read the whole thing because you can read it if you like. But the general idea is it is a generalized information about that that's not tailored to a specific individual situation. That's the big difference, I'll say. And I like to use, even just as an example, anyone can give legal information. There's no prohibition. That is not the practice of law when we're talking about legal information. And again, I get a lot of calls saying, hey, this person's doing EPL. They were giving this legal information. That's not, for instance, what I'm doing right now, I am giving you legal information. I do not need a license from the state of Colorado to come up here and talk to you about even UPL. I'm just giving you information. There's First Amendment rights. There's all kinds of great things that go with that. I'm just giving you information. So, but there's a difference between that and legal advice. And legal advice, again, you can see in contrast is, unfortunately, advice that is specific to the unique circumstances of the inquirer. It is strategic in that it offers an approach that is tailored to the fact situation of the asker and goes beyond more general advice appropriate to all persons. And here you can see the site from the ABA standards is where we get to some of these definitions. And again, I like to point out this can be both, in the past and in the future. So we can both be talking about advice in the sense of what have you done and what does that mean legally, and or advice about the future. Okay, what do you want to do and how would that be impacted? What are the legal options that you have now going forward because of the horrible thing you did or the great thing you did? I don't know. That kind of specific legal advice that's tailored to a specific person, a specific situation, that is when we start to get into the practice of law. That's where we have the practice of law. Also important when you think about it, when you get to that point, you're usually developing, when you have a license, an attorney-client relationship to some extent, whether that's limited or not, whether you're in a legal clinic, that's a topic for another day, but also to keep that in mind, even when you're having some of those, you know, just barroom conversations or something like that. When that happens, you know, be aware this is usually what starts to create a attorney-client relationship as well. So, whoops, sorry, other way. And where is then a lot of this defined? This is under the new rule 232.2 B that defines what is the practice of law. We're going to go through a few of them here. I'm happy to start to answer any questions about, you know, what that looks like, what that is, but keeping in mind that this is actually, I'm not even going through all the subsections just because reading you subsections gets boring and I don't like to be bored. So one of them, it is right out of the rule, you know, subsection 1, protecting, defending, or enforcing the legal rights or duties of another person. I mean, it's a little vague in the sense it's very broad and encompassing, but hopefully it's also a little bit obvious that, yeah, once you start doing that, you're starting to protect the legal rights of others, you know, you're practicing law. Similarly, representing another person before a tribunal. You know, LLPs, attorneys, et cetera, you know, are doing that all the time. That's just more one of the classic examples of, you know, obviously when you go into court, you go before any kind of tribunal, ALJ, something else, and you are representing another person in that proceeding, you are practicing law. You're representing another person. You're defending, you're kind of doing back, defending or enforcing the legal rights of someone else. But you don't have to be in court, obviously, to practice law, as we know. You can do that in large part without ever going to court. So if you are counseling, advising, or assisting another person in connection with that person's legal rights or duties, that is also the practice of law, which, again, hopefully is obvious in the sense when we say it that way, but isn't always as obvious when we're talking about the real facts, when we're talking about what's happening out there. Because this is where it can come into the, you know, legal information versus, you know, legal advice. You know, is a court clerk just telling you, here's what the filing deadlines are in a case, or is this someone telling you, you should file this now, or you need to file this now, or you have the right to appeal, or you don't? Or again, is someone just providing some general information about the court process, or, you know, what's happening, you know, with immigration law, or you know, what the tax code currently reads. This is where a lot of people start to go wrong, though. This is where we catch a lot of people that just, even in the best of intentions, start to cross the line. Because as soon as you start also exercising legal judgment and preparing legal documents for another person, you know, then you're also practicing law. Because there's a lot, hopefully we all know, or you can realize if you think about it, how much legal knowledge goes into when you're crafting or drafting a document. You know, if you're doing that, you're making some decision. What do you put in? What do you take out? What words do you use? You know, what's going to be the impact of that? And that is going to be the practice of law. So I also want to indicate, and there's also a separate subsection for this. It includes selecting even prepared legal documents. So those JDF documents that are on the court's website, various USCIS forms for immigration work. You know, there's a million preformed forms out there that you just have to go out and download. So you think, well, if someone just helps me go do that, is that the unauthorized practice of law? I'm saying, well, it depends. If someone just goes and helps you download a form, no, that's not the unauthorized practice of law. You don't need to call OARC for that. Now, is someone telling someone which form they should download, which form they should fill out? Yes, that is a problem. So, again, and you can, again, if you think about it a little bit, although this is usually where people go wrong, is they don't think about it a little bit, is, well, you know, it just seems obvious. They're, you know, divorced with, or they want a divorce, there are no kids, this is the JDF form, I'm going to go do that. Or they want to apply for citizenship, here's the USCIS form, I'm going to go help them download it, I'm going to tell them this is the form they need to use. But as soon as you start selecting and telling them what form they need to use, you're already making, there is some implied, there is part of that that's legal decision making. Maybe there's something else you're not thinking about. Maybe there's a question you're not asking. Maybe there's some other facts you're not aware of. Maybe they shouldn't be applying for asylum at this point, and they should be applying for a different process that's going to lead them to that. Maybe you shouldn't be even applying at all because it's going to, the rejection is going to lead to a deportation proceeding or whatever the case may be. Obviously, like I said, this is where that little bit of knowledge can go a bad way because someone who knows, this is what it is, this is what I tell everybody to do, but they're not aware enough to know for the danger zones, the potholes, the areas that might go back. So as soon as you start telling people which forms to download, you are also practicing law. Again, there's some subsections about holding yourself out as a lawyer. Of course, that's not it. Or, advertising legal services and collecting fees for legal services and those types of things as well that go into that. But for the moment, we'll get through that. Hopefully, we've got a basic general idea. Again, if there's some questions about it, I'd love to answer them now, but again, generally clear. What is the practice of law? Sorry. Yeah, so I'll repeat the question. Yeah, so the question is, what are my incredibly profound thoughts about real estate brokers and their filling out buy-sell forms? And we're going to get to that. So, because now we're getting into the authorized or not. So I guess my thought for this half is, yes, that is the practice of law. You're exactly on the point of it. And then we have to talk about, is it authorized or not? So when you're talking about, is this the right buy-sell agreement or not? Yes, practice of law. So when is it authorized? Well, there's a few different things, of course. You have a license to practice law, you can practice law. I said, sigh of relief up front. No worries. We're not going to just go get injunctions against everyone here today. They collected your names at the door, so we know who to get. LULPS. I still don't know how to, my Colombian wife likes to try and pronounce every acronym, or make every abbreviation an acronym and try and pronounce it. So LLPs, I just like saying LULPS. In certain domestic cases, like we're saying, at least for right now, their authority is limited to domestic cases, so we're just going to talk about domestic cases. But they can also practice law in those areas as defined by 207. Some out-of-state lawyers, even if you're practicing Colorado law, but you are an out-of-state lawyer, now you have to comply with 205.1. I will please encourage anyone that as soon as you encounter an out-of-state lawyer and you want to call our office because there's UPL, please read 205.1 before you do, because there are exceptions for being able to do it, which essentially means if a Florida lawyer sends something to, but they are living in Florida, practicing in Florida, not advertising in Colorado for Colorado clients, they're just living and doing that there, and they just happen to send something to your client who lives in Colorado, they're not going to be, this isn't going to be UPL. That 205.1 is that carve out, that they don't have to come get here pro hoc in just because they're sending a letter to somebody in Colorado. Although it might technically be the practice of law in Colorado because of whatever they're doing. So look at 205.1 before you call us, please, because I've had more than one call with a licensed attorney that said, have you read 205.1? They can do this. And other licensed regulated professionals. So there are some carve-outs for that. And if we had a full afternoon and I didn't have another just 20 minutes, we might go through a whole long list of it. Real estate brokers is just a really good example of it. The Colorado Supreme Court has essentially carved out, especially there are other separate regulated professions, they get to do it, but in very limited ways. So your real estate lawyer can help you find which buy-sell agreement to write, how to modify that, what to do. That's authorized by the Colorado Supreme Court. But they can't go out and help you pull down the right JDF form for getting a divorce, for example. It should make sense. But so there are other examples of that. Like really, the real estate is probably the best one because it's the cleanest one. But there are other even authorizations for representing individuals in unemployment hearings, and there's some administrative exceptions. And like I said, there's a long list. You can go to our website if you want. And we have a nice, it's like a page long. And we used to have a slide about it. It was really boring, and no one liked to read it, and I don't like to read it, so I cut it out. But you can look at our website. So, regulation. How are we regulating these things? Or again, can we? I mean, again, at least generally clear on when we're talking about what's. So we have what's the practice of law? Is it authorized or not? Those are the first things that that's the entire analysis I'm really doing when someone calls me and says, "Hey, I've got someone UPLing." That's kind of like, well, is it? Is it regulated, is it authorized? There is another part, and we'll bring that back. I mean, this is, and are you calling us just to protect the wizard's book? Or do we really have a danger to the public out here? Because, again, you can, and I won't spend all of the time with theoretical questions about, well, what about the dad helping his son fill out some, insurance forms, and, he did that, and, how much interest does the Colorado Supreme Court have in regulating that and saying every parental in a relationship where they're actually helping their child fill out a form is going to be a UPL, and they need to call us immediately, and we're going to get an injunction? We'll save that for the law school classroom and not today. But just, there is a very much, this is why I'm talking about the start of it is why. Why are we doing it? Why are we regulating it or prohibiting it? Jerry?
Where do Sherlocks fit in that scheme? The self-help assistance at court.
Yes, the Sherlocks. Jerry's asking, where does Sherlocks fit in that scheme? That is another one of those exceptions by the Colorado Supreme Court rule that defines what Sherlock. So the court personnel that are helping, guiding, especially pro se parties through the court process, and often helping them maybe figure out which forms to find or download or do some of those things. There is a particular Chief Justice directive that speaks to Sherlocks and what they're doing at the courts. So yes, I mean, again, there's another good example. There are, like I said, these exceptions that exist out there. Any other questions about UPL? So, how do we regulate it? Well, we investigate it. I feel like I should just kind of stop there, but that's maybe just boring. But I'm going to get into what I kind of, because this is going to be more interesting to anyone who's actually wanting to get into it. But so I might pay a little short shrift to some of these steps. But I want to make sure it's clear how we do that, including if you have to call us. Because again, we are a complaint-based process. So as with disciplinary cases against lawyers, the unauthorized practice of law is also complaint-based. We need someone to call us and be a complaining party in our process. So, and at the resolution, when someone calls us, what happens? Well, in short, there's about three options of what we do at the end of the day. We can dismiss it outright if it's hey, I overheard the dad talking to his son about, what he might be able to apply for at student and financial aid. You really need to put a stop to that. And we're going to say, go away. But beyond that, if there's some other things, maybe it's a little more closer to line, we can dismiss things with educational language. We can enter into a written agreement with the Legal Regulation Committee. And there are injunction proceedings. But it is a civil process. For what it's worth, that's our process in Colorado. And especially those of you who maybe come from other jurisdictions, practice in other jurisdictions, are aware of other jurisdictions. In other jurisdictions, it is a crime to do UPL, and those are criminal issues for the DA's office. In Colorado, it is us that does that. The Attorney General has some overlapping consumer protection issues with regard to the Consumer Protection Act and some other things like that. Criminal impersonation of an attorney is a criminal matter, and there's some overlap in those situations, but it is otherwise a civil process in our state. And that civil process is an injunction, which I also like to remind callers of many different forms, which means it is a different analysis from a disciplinary situation with a lawyer. With a lawyer, of course, I'll tell you this, when we call, we're looking at what did the lawyer do? Can we prove by clear and convincing evidence that there's a violation of the Colorado, rules of professional conduct? And if so, will then the court discipline that lawyer for this bad thing that they did in the past? It's a different analysis for the UPL. We are looking at, yes, what did this person do, but it is prospective in the sense of, is the court going to enter an injunction, because we have the same injunction burden of proof that anyone else in a civil case has, that prospectively, are we going to stop the unauthorized practice of law? This is also one of those things, like I said, it comes into this, what are we doing? Why are we doing it? That's what I'm saying. The why talks a lot about the what and the how. So it is prospective in that sense that we're not out there to punish people that have done the bad thing in the UPL. We don't have the authority to do that. Now, through those injunction process, we can make them repay fees that they shouldn't have collected, so there's a restitution process. You shouldn't have collected those fees, you need to give them back. And there can be some fines or something like that, depending on the situation, but I'll tell you that's almost really when we get to contempt, if we get that far. But it is really paying back fees, stop doing it in the future. But that's our focus as well, is looking forwards as far as, can we stop this going forward? So there has to be this danger of it continuing. Again, is this father going to continue talking to his son? We need to put a stop to that immediately. Whoops. And contempt proceedings. So, like I said, if we have time, we'll talk about that. There is a new contempt proceeding through the new rules that does really beef up our ability to enforce that injunction. That's great. If we have some questions about that, I'm happy to talk about that in a little bit more as we get through it. But generally speaking, I want to also highlight what kind of people are we investigating? What are the kind of people that come to our office? People that are preparing documents in immigration cases. This is a big case. I mean, this is a big category of cases that we have that come in the door. In especially times as these, I guess I will say, there are more fears, there are more people that pop up that have a little bit of knowledge. They are the sorcerer's apprentice, and they start giving a lot of advice. And that can be a very dangerous thing. So this is a big category of what comes in. But they're not the only ones. Trust and estates, it's another one that tends to come up quite a bit. That for people that are out there, preparing trust and estates documents. And again, you see there's a lot of forms involved here. But there's a lot of decisions to make. What's the right one to make, and are you doing it the right way, and things like that. There are, I don't know if you're all familiar with sovereign citizens. They are another category that comes in. This is particularly a concern, honestly, for the courts. This is kind of really tends to gum up the courts in large part, and so we have this other part of, protecting the administration of justice. And, the sovereign citizen that comes in and starts filing things on behalf of other people and purporting to do it maybe through a power of attorney or some other, I don't know what in commas legal document, can really gum it up. So that is another general category of person that comes in. We do have occasionally the person purporting to be a lawyer. We've had a few of those cases over the years. They're not the big bulk of what we do, but we do have some people coming in claiming to be lawyers that are not. Usually relatively quickly uncovered, I think. But we do have those. Then, of course, there's other categories of people as well. If we have all of the people that have been ordered, that there's an injunction against them to stop engaging in UPL, you can go to our website and see that. One of the hopes also through the process is that this gets into, this Google and other internet searches as well, so that if someone maybe looks up an individual or a company's name, they will uncover that there is a injunction against them, and then maybe be forewarned that they shouldn't give their money to someone that is not otherwise licensed or otherwise has an injunction against them to practice law. So, and in particular, as those of us with license to practice law, what does it mean? You also need to make sure, of course, you're not helping anyone do that without also taking a long side trip down that category, that area, because there are some lawyers that kind of, what we say, kind of lend their license to somebody. They just okay, they're pretty good at it. It's the sorcerer that, again, is handing out, this apprentice is actually pretty good. He casts a lot of spells. He's done a pretty good job over the years. I'm just going to kind of let him run with it. He gives me a little kickback, but he's taking care of things and otherwise not supervising someone else. Be aware that can and has had problems for a number of lawyers in the state of Colorado. I have a case on my desk now where that's an issue. So be aware under 5.5, make sure you're not helping anyone in that unauthorized practice of law, or that can come back to you as well. So what does the investigative process look like? Again, I'm going to give this a little short shrift for two reasons. One, I really, really hate this graphic. It's not any more accurate 100%. But is currently what we still have on our website. And there's a person in our office that's supposed to be updating it and hasn't done it yet. So I apologize for that in advance. But we're getting just too many calls at the moment, so it just hasn't happened yet. But here's kind of the flow chart. Like I said, it is a complaint-based process, and I do want to be clear about that. Also in the sense of, because we do get a lot of calls or questions about, an anonymous tip, someone in the community that just wants to let us know. Because sometimes these UPLers are someone respected otherwise in the community. I mean, there are a number of people or cases that we've had, it's the church pastor, or priest or minister that's otherwise helping someone out but going too far. Sometimes they're charging for services and things like that. There are a lot of cases, again, this goes back to some of this, what our options are at the end of the day. There are a lot of good-natured people that just get into UPL. They start helping in one area, they're doing translation, for example, and they just go, I'm just helping people translate, put the answers down in the form. They've now looked at a lot of the USCIS website and they feel pretty comfortable with it. And they become the sorcerer's apprentice, starting thinking, well, let me just, charge me a little bit more and I'll help you through this process a little bit more. And step by step, they get deeper into it. But they start and really often are with the best of intentions. Those are the ones we're looking at stopping somewhere earlier in this process. I mean, depending on how far they've gone down this line, again, we may be just dismissing it with some educational language to say, listen, here's where the lines are. You got either close or you stepped over it a few times, but, you gave, sometimes we do have the people that, they already gave it the money back by the time, it's even coming into our office. So we're saying, just be aware, here's where it is. If it's a little bit longer, further down, or there's a few more things they have to pay back some money yet, again, we may be looking at doing this agreement with the Legal Regulation Committee, where it's more part of a formalized process. If they have to pay, they're going to pay that back. They have to make modifications, maybe sometimes to their website because it was a little unclear, or there was something else that they were doing along those lines as well. But we have the bad, the bad people. We have the fraud, people that are just out to take advantage and take money and get in and get out. that charge. Sometimes it is amazing to me how many cases we come in, and you'd think sometimes the UPL, because there's an access to justice part of APL, isn't there? I mean, there's also that, well, I mean, people need help. There's a lot of people that have a few immigration questions in April of 2025, and what does that mean? And can they all go to lawyers and get the answers, the questions answered? But again, you would be amazed how many times I see they have paid UPLers 3 times, 4 times what an immigration lawyer would charge. And so it just also, something about, did you even price around immigration lawyers before you gave tens of thousands of dollars, for the same work that was bad work to this person that didn't have a license to practice of law? And no, there is, for what it's worth, while we're talking about, there's sometimes a cultural component to it. I'm skipping past that in a little bit in the interest of time. People that misunderstand different rules in our legal system as to how that works. As you might imagine, also in the immigration context, what a notario is in a Latin American and civil law country is significantly different than what a notary public is in the United States, in Colorado. And there are specific, advertising regulations with regard to that, to not advertise in foreign languages that in that area of that. But, again, sometimes there's a big misunderstanding with regard to that. But, so there's a intake process, there's a trial process, trial investigation process, similar, especially under the new rules, to what we have in attorney disciplinary cases. Again, I'm going to make a little short shrift to that, but if there's some questions about it, I'm happy to talk about it, or you could catch me right after I finish. But one of the things I want to, I guess, in particular highlight at the end of this is the new contempt process that is, I'll show you a slide on the screen that's no longer accurate and tell you about it. Here's why what it doesn't say. The new process does allow us to actually, for a contempt, the Supreme Court can assign it to a district court to hear the contempt proceeding in regard to an UPL injunction, which is particularly useful for us for me, interesting, but most people not, academic reasons about the process of, if you have, because there can be criminal contempt, and we have sought that. And then, how do you, well, if it's the Supreme Court sitting as a tribunal, which county do they send them to, to hold them, or, who issues or who executes the warrant and those kind of things. That has been cleaned up with these new rules. So that hopefully makes it it has a lot more teeth into it than it used to have. And we're hoping that works that in the, fine procedures and things like that at the contempt stage have been beefed up and numbers increased. And so hopefully it's a little scarier by the time you at least got an injunction that we're going and looking at you, what we can do at that point. There's also, with the restitution order, it's now similar to a criminal restitution in the sense that victims can they can go through a process to enforce that through themselves and don't have to depend on the Office of Attorney Regulation Counsel to do that for them, and some other things that are very helpful. So, unless there's, I can talk about that all day, but it's only interesting to me. So how do you file a complaint for UPL? It's essentially the same way you file a complaint with anything else with the Office of Attorney Regulation. You can call us, that number. You can call us in Spanish at that number. You could call us in another language, but we probably can't answer you. But you can write to us in any language. I will say that. We will make the effort to understand it. We have done that with a number of different languages. We will figure out how to understand whatever you've written to us is. So you can, but that would be in writing, because again, if you call us, we do not have that many different language speakers. And you can write to us at that address. There's also an online complaint form, and you can do that with the website here, the ColoradoLegalRegulation.com. That'll direct you there pretty quickly to how you do that. And there are both English and Spanish versions. Again, you can do that in another language, fill it out that way. We will figure out how to read it. I will say again, with regard to the point I was making a moment ago, that there are no anonymous complaints. So we do get that a lot, to say, like I said, there are community leaders, there are people that are just, well, this person is going to retaliate against me. What are they going to do if they know I've reported them? And unfortunately, like I said, it is a complaint-based process. So we are, for one, really relying on people to call us and let us know. For what that also, I guess I will say to licensed professionals is, and a lot of our calls do come from you, from the bar. I mean, you might think they come from victims. In large part, they come from you. So, that's a part of the reason why I'm talking to you about UPL, is to come and say, yeah, when you see it, when you have that client that came in and said that, and when you tell your client to call us, which I know a lot of people do, they don't always call us. And I just encourage you to be the one. In part, it's because of those things. They know there's some retaliation. There's a different extra level between you and them with regard to this community leader. Your name is on it instead of theirs, et cetera. So I just do want to encourage you in the sense, and going back to, why are we doing this? And without getting too far up on my soapbox about, why we got into law, to be protectors of truth and justice and all those great things that make us be proud to be lawyers. But really, it's about protection about the public. I mean, that's why we do it. We do not do it. I mean, if you're one of the ones that says, well, you shouldn't do it just so my license is worth more, you ignore everything I said. Don't call us. That's not what we want to hear from. That's not why we're there. It's certainly not why I work in the office, is just to make my law license more valuable. It is to do the work to protect the public. It really is these, this little bit of knowledge out there, and people are, destroying lives. So, when you think about, UPL, and again, the questions, you're thinking about these unbelievably powerful lasers that can destroy planets, or maybe just people's lives, that you're calling us, that you're making the effort. And I know it sometimes takes a lot more effort, because sometimes we're asking you, say, can you send in a little bit of information? We can talk about, again, there's a lot more other things we could really talk about with regard to that. But I know I'm going to run out of time. So you're welcome to talk to me about unbelievably powerful lasers or the unauthorized practice of law. But, questions, I mean, like, what gave the Star Killer base its unbelievable power? Or does anyone remember why the Death Star had its power? Or something else, but, so I'll summarize. How do we deal with that in the transactional world, and particularly if you're dealing with a maybe complex transaction that has people from different jurisdictions and potentially representatives from different jurisdictions or something to that, again, and in particular with looking at 205.1. Well, there's definitely a difference between what I'm going to say is the procedure I just told you, which maybe I should have started with this too, is this is the procedure if someone does not have a license to practice law in any jurisdiction of the United States. So, that's, if they have a law license in some other jurisdiction, we're looking at disciplinary rules, RPC rules, even if they're engaged in potentially the unauthorized practice of law in Colorado. That would be more of a 5-5 analysis that we're doing. And again, we're looking at the RPCs rather than this section. This applies to people who have never had a license or disbarred lawyers. This also applies to people that have been disbarred. But I guess I'm really going to punt on your question in the sense of what, it really, if you have 205.1, and we can talk about, different jurisdictions and different things, if there are a different thing, with you going outwards, you're looking at what are the rules in the other states which I can't talk to intelligently because I don't do it. And with them coming here, we're looking at 205.1 for people that are doing that in some method. If they have a license in some jurisdiction, it would be looking, do they qualify under 205.1? Again, 205.1, again, if you're going to be appear in court, you got to get pro hoc. If you don't, you don't. And it really is, are you just complying with these other things? You can't move here and qualify under 205.1. That's like, one of the subsections. But again, I feel like I'm really not answering your question. Yeah, you just have to look at each state. But I know I'm out of time. I've run over. Thank you very much for all your time this afternoon.
Thanks, James. How we doing? Our next speaker is Jack Tanner, and we're going to have him rock through the some of the day-to-day rules of conduct for you, and then we're going to have a break. So bear with us, hang with us, and we're going to play with some technology. Jack, hi. Yeah. And Jack is currently the vice chair of the ethics committee, and your chair.
I'm past chair.
Your past chair.
COVID chair, 2020. Time flies.
Well, I was chair in 2000, so. And Jack's with Fairfield and Woods. He has his BA from Rice and is a Duke Law School person, many years on the ethics committee. Let's welcome him, Jack. Thanks.
Thanks, John. Yeah. I have the record for the best attendance I have the record for the best attendance as chair because I was the COVID chair during COVID, and so all the meetings were by Zoom. And we had and nobody else had anything to do, so we had 95% attendance. So that was good. Hey, I don't know where y'all went to law school. As John said, I went to Duke, and the professors at Duke were academicians, and they didn't always appreciate, to me, in retrospect, that they were teaching at a trade school, and their job was to teach us a vocation. So when I took ethics, brilliant professor, we'd get questions like, a member of the Gambino crime family brings you a rifle. He says it was the second gunman used on the grassy knoll. What do you do? Nothing to do with my practice of law. I didn't learn anything like that. Oh, this is a disaster waiting to happen. I'm going to move this. So about 20 years ago, I got invited to give a speech to the brand new lawyers that had just been sworn in. So that's the origin of this speech you're going to get now, which is everyday ethics. This is the stuff when you're actually practicing law you probably need to know. And just as a heads up, I welcome your questions for sure. This speech usually takes about an hour and 15 minutes, and John gave me 40, and James went long. So I'm going to fly through this material, and my apologies, but that's the only way. Okay, in the 2008 rule changes, the biggest rule change to come out of them, weirdly, was in the scope. And what the scope was changed to say is that the rules of ethics can be directly admissible in things beyond disciplinary proceedings. Prior to 2008, that was not the case. And what that means is these rules can be directly admissible in, for example, a malpractice case against you. Therefore, the stakes went way up. I mean, we all want to be ethical lawyers, and you don't want the OARC coming after you anyway, but now they basically do set a standard of care for the practice of law generally. So you need to know your ethical rules. A couple of things. Terminology confirmed in writing means one of two things. There's a bunch of rules things that have to be confirmed in writing. Two things. One is the client actually sends you a writing. A different one is you have a conversation with the client and you send a confirmation shortly thereafter. As we just discussed, you've consented to my representation, blah, blah, blah. Those two things are confirmed in writing. What is not confirmation in writing is you sending an assumptive email, for example, to the client and say, this issue came up and we've been through this a bunch of times before. We've been down this road. You've always given me consent before, so I'm just going to believe you're giving me consent now to this conflict, and if I'm wrong, let me know. That is not confirmation in writing because you're not confirming anything. Okay, firm can include an in-house legal department. No means actual knowledge, although it can be inferred from the circumstances. The Ethics Committee relatively recently came out with an opinion about basically willful blindness by lawyers who, I think this arose out of like lawyers that were laundering money for drug cartels or something, but the idea was, wait a minute, the client gave you $800,000 to hold as a retainer to defend them on this dog bite case, really? So knowledge has to be actual knowledge, but it can be inferred from the circumstances. Informed consent, some things can only be done with informed consent. That is a higher standard than the prior consent under consent after consultation. Informed consent means the lawyer actually has to explain to the client the facts that are known, the law that's known, and give the client enough information that a client could make an intelligent decision. This model was based on the SEC, Securities and Exchange Commission idea when they review an offering memorandum after everything's gone to hell and all the money's lost, and they look back at it with 20/20 hindsight. Was that offering memorandum, did it really disclose to the potential investor everything a potential investor would want to know? That's the model that was used for this rule. So informed consent, you can't, basically under the old consent after consultation, you could tell the client just enough to get the client to say yes, and then you could stop. That's not true anymore. We're going to, unfortunately, have to skip these hypotheticals because I don't have time. So now we're in the actual rules. 1.1, you have to be competent. There's a great case out of San Diego that the hypothetical I just skipped over was based on, where a two-person real estate firm had a client that called them up and said, hey, I'm an investor in this little company. I got sued in a patent litigation matter. Can you help me? And the two-person real estate firm said, absolutely. It then promptly outsourced the case to India. For those of you that don't know, there are more unemployed engineers in India than there are engineers in the United States. And so one of the things some of those Indian engineers do is they have patent litigation support companies. And they're really good. And this company told the San Diego lawyers how to answer the complaint, how to do their Rule 26 disclosures, what questions to ask in discovery. Based on that, they drafted a motion for summary judgment, which won. They won the case. And literally at the celebratory dinner, having won this case on summary judgment, the client said, how'd you come up with that theory that you won the case with? That was when the lawyers told them, oh, by the way, we outsourced your case to India. And the client grieved them, and one of them got suspended from practice law for 60 days, and one got suspended from practice law for 90 days for winning a case on summary judgment. Because what the opinion said is, you weren't competent. You didn't know. As it turns out, you got good advice from this Indian patent litigation support firm, but you could have got bad advice and you wouldn't know any better. So the first rule is you have to be competent. If you don't know what you're doing, you may have to turn down the work. This, by the way, is where artificial intelligence comes in, and I know that's a hot topic for everybody. Is anybody speaking about that today?
Not today.
Okay, well, so here's the deal. It's a big unknown right now because I'm sure many of you have heard of that idiot lawyer in New York that had ChatGPT write his brief for him, and it made up cases that did not exist, and then the judge got suspicious, and because the other side pointed out the cases didn't exist, and so the lawyers went back to ChatGPT, and the program made made up cases, hallucinations they call them. So it's not competent at this moment to rely on AI alone, but at the same time, you have an obligation under Rule 0.1 to stay up on current technology. If there is an advance in the law that lets you practice law better, an advance in technology that lets you practice law better, you have an obligation to take advantage of it. So basically, keep your eye on this because things are changing. Okay, Rule 1.2, the client decides the aims, the lawyer decides the means and method. You cannot give advice to a client to commit a crime, nor can you assist a client in doing so. And this is any crime. When we get to the end and we talk about criminal conduct by lawyers that is itself an ethical violation, it's a narrower group of crimes. But for Rule 1.2, you cannot advise a client how to commit a crime or assist a client in committing a crime, period. The exception being in Colorado, dope and soon to be magic mushrooms, which are still federal offenses. Okay, diligence and communication. Keep your client apprised of everything you do. This is another thing that the lawyers in San Diego got in trouble for, because they didn't tell their client, oh, by the way, we outsourced your case to India. If they'd done that and they'd gotten client informed consent from the client, it would have been fine. But they didn't tell the client till the dust had settled. As a general rule, again, back to practical matters, return phone calls same day. Most clients don't know if you're a competent lawyer, but they know if they get their phone calls returned. They know if they get responses to their emails in timely fashion. So that's one of your ethical obligations, plus it keeps your client happy. Also, it keeps the client informed. They don't get surprised when they get a big bill. What do you mean you spent 14 hours responding to a motion? I didn't see the motion. I didn't see your response. Send copies of everything to the client. This creates an interesting problem in the world of email, because in the olden days, when I started practicing law, it was, hey, I got a letter from the other side. I'm going to photocopy that letter and send it to the client. Right. In the days of email, when you get dozens of emails a day, there has been a lot of back and forth on, do you, especially when you're responding to those emails, one good way to keep the client informed would be to CC the client. If you do that, by the way, you're consenting to the other side responding to the client directly without, I mean, you have to be included on the reply to all, but you're consenting to the other side talking to your client directly. Second, you can't necessarily get around that problem by BCCing the client, which used to be what I used to do, as I would BCC the client, because, speaking of idiots, there was a case, I think, out of South Carolina, where the lawyer BCC'd the client on something. The client replied to all and disclosed something important. So the client waived the attorney-client privilege by replying to all. The client then sued the lawyer for malpractice and won, because the jury decided it was reasonably foreseeable that the idiot client would reply to all. And so the lawyer cooked his own goose by BCCing the client. Therefore, on emails, the recommendation is what they call the two-email solution. You send an email to the other side, then you forward it to your client and say, here's an email I just sent to the other side. That way, if the client inadvertently replies to all, they won't be replying to the other side. Fee agreements should be in writing. You have to communicate the fee agreement to the client in writing. The client does not have to sign it and send it back. Most of your partners and whoever that helps collect bills would love you to have a signed engagement letter. Your malpractice carrier would love for you to have a signed engagement letter, but it's not an ethical requirement for just an hourly fee. Any agreement regarding fees that's not straight cash is actually covered by Rule 1.8, which we'll talk about, is a business transaction with a client. So if, for example, the client gets way behind on the bill to you and they give you a promissory note and it's secured, or even if it's not, if it's just a note for the back fees, that's a business transaction with a client, and 1.8 applies. Contingency agreements do have to be signed by the client to be enforceable. There's a form in the Rules of Civil Procedure for a good contingency fee agreement. And I gotta tell you, this is, that means any kind of interest in the outcome of the case. There's a case out of, I think it was California, where an in-house lawyer was going to quit on a case because he was working too hard, and he went to the boss and said, I can't keep doing this. And the boss said, tell you what, you stick with this case, I'll give you a percentage of the recovery. And this was an in-house lawyer. This was an employee. And he hit the jackpot, and then and the boss didn't want to pay him his bonus that was supposed to be based on his recovery. And the lawyer sued to get the bonus, and he lost because the court held that that was a contingency fee, and he hadn't gotten the agreement with the boss for his bonus in writing. And it was not a proof problem. It was admitted that the boss had agreed to this, but this is something that's got to be in writing. You can't have a contingency fee case in a contingency fee agreement in a domestic or a criminal case. Fees have to be reasonable. You can't bill two clients for the same work or the same client for two different things at the same time. So, for example, you've got a client that's willing to pay your travel time. You're sitting on an airplane and you're billing client to sit on that airplane. While you're sitting on the airplane, you do some work for client B. Can't bill them both. Even though both would be happy and it's fair that you did them both, it's unethical to bill both two different clients for the same work at the same time, or for the same time. And in fact, you can't even bill the same client for the same time. For example, if when you're on the plane, you're reviewing documents for that client, you can't say, well, I sat on the plane for 3 hours, and while I was on the plane, I did 1 hour's worth of work, therefore I'm billing the client 4 hours. Can't do that. Even if, when you get to the hotel room, when you've arrived where you're going, you could spend that same hour working on that document. You can bill for that then. That's 4 hours. But you can't bill more time than you actually expend on a matter. You can't mark up costs except a nominal amount to cover administrative overhead. Boy, I wish I had time to talk about this one, which is based on an ABA article called Scadnomics. And actually, I will digress on this for a minute. I remember reading this article when I was clerking on the Supreme Court, and they were talking about this law firm who will remain nameless, but the article was called Scadnomics. And it was saying, and they were, Scadnomics was one of the first firms to really get into big bankruptcy cases. And so their fee applications got filed with the court and could be reviewed. And so this article says, not only are they charging the client for the pastries that they serve at client meetings, but they're marking it up by 60% from what they actually pay. So I know all you good lawyers are all having the same thought at this moment, which is, how do you find clients like this, right? that are willing to pay for that? So anyway, that article led to an ABA rule change, which led to a Colorado rule change, which now says, basically, if it costs you 9 cents to make a photocopy, you could charge 10. If it costs you 9 cents to make a photocopy, you can't charge $1. You make profit practicing law, not selling donuts. Again, on fees, if you've gotten a retainer, the matter's over. You haven't spent it all, you've got to give it back promptly. You have to inform the client in advance of any changes to your hourly rate. What you should do on this, again, this is practical, put it in your engagement letter that you can raise your rates whenever you damn well please. And then you can raise your rates whenever you want. If you don't put that in your engagement letter, you have to tell the client in advance you're going to. So most firms raise their rates January 1. And in December, you'd have to send a letter to clients saying, hey, in January, we're going to raise our rates. That'll annoy everybody at the holiday season. So instead, you put it in your engagement letter that says you can raise your rates. And then they find out you raised your rates when they get your January bill in February. Referral fees are prohibited. This is the shortest rule in the rules of professional conduct. It's not really true, but in terms of express, there are ways to get around this rule, but in terms of express, I got a referral last year from somebody in Chicago, and he's like, yeah, and I'm going to want, a referral fee, like 20% of the fees or whatever. And I was delighted to tell him about Rule 1.5E. Sorry, can't do it. No referral fee coming from me. One of the ways you get around the referral fee is when both lawyers stay involved in the case, and then you can divide the fee. It's got to be fair to the client has to agree to it, and it's got to approximate the work you're doing on the case. It doesn't have to be exact, but it's got to be close. So the referring attorney can take a bigger share under that circumstance. Okay, let me say this. Rule 1.6, client confidentiality, is the most important rule in the rules of professional conduct. Second, it is the most violated rule in the rules of professional conduct. It is really important. So, you file the lawsuit, the complaint hits the papers, one of your law school buddies sees you and says, hey, I saw that complaint you filed, let's chat. No, you can't talk about that because it's client information. It doesn't matter that it's available from another source. You learned about it representing your client. Those of us that have been practicing law a long time remember the phrase confidences and secrets. That was from the old code. When I went to law school, to the non-trade school I went to, I learned about confidences and secrets. That phrase does not appear in the rules. Client information is anything you learn in the scope of representing your client, and you cannot talk about it unless one of these exceptions applies. And chatting with your law school classmate, because what he or she saw in the paper is not an exception. Here are the exceptions. Prevent death or serious bodily injury. These are permissive. There's only 2 rules that actually trump 1.6. All these exceptions we're going to talk about are permissive until we get into some other rules, and I'll tell you what's mandatory. Prevent crime or fraud resulting in serious injury. Rectify serious economic injury caused by crime or fraud where the lawyer's services are used. This grew out of Enron, because you may recall after Enron, WorldCom, Tyco, whatever, there were congressional hearings, and they had the lawyers. I remember for Enron, the lawyers from Vincent and Elkins, when $1 billion is missing from the pension fund, and the senators and congressmen are saying, Mr. Vincent and Elkins lawyers, where'd the money go? And they were swearing under penalty of perjury. I can't tell you. That's client information protected by Rule 1.6. And at the time, that was correct, because this exception to rectify economic injury was not in the rules. So as a result, they changed the rules. So now, if your services were used in the commission of an economic crime, you can, not required, but it's permissive, you can disclose that information to rectify the damage that was caused. Other exceptions, this is a great exception that came out in the 2008 rule changes. Now lawyers, you folks, can go hire your own lawyer when you think you stepped in it and you need your own legal advice, which is a great exception. This wasn't here until recently. And for those of us that work at firms where there are other people that also have ethics work, I'm delighted to have a partner named Cecil Morris who knows more about this stuff than I do. And so we can chat with each other when we have problems, and other people in our firm can come to either of us. But for sole practitioners, small firms, nobody who really does this all day, this was a real problem. So this was a good rule change in the 2008 rule changes. Dispute with a client. Yes. If it has client information in it, that is correct. The easy way to get around that is to ask the client for permission to do it, because client consent solves all this. Right? So you call your client and say, hey, there's a buddy that I work with. I send him stuff, he sends me stuff, and I want to share some of this analysis with him. Is that okay? And the client will say, fine. Doesn't even have to be in writing. You can just get the client to say yes over the phone. Then you can do it. But if you're going to do it without client consent, I would suggest you take the Word version and pull out all the parties' names. Because yes, that would be disclosing client information. Oh, this is an interesting thing. One of the other exceptions here is a dispute with the client. And the question is, if the client is unhappy with your services and says, hey, that guy disclosed, he sent a copy of my motion to another lawyer and he shouldn't have done that, right? Whatever, the client writes smack about you online. Can you respond? Are you disclosing client information? Is that a dispute with the client? And the ABA rule and the majority rule is no. You cannot. That is not a dispute with the client sufficient for you to be allowed to disclose client information to third parties. Colorado, I'm delighted to tell you, follows a minority rule that says, yeah, if the client talks smack about you online, you can respond, only enough to set the record straight. When the client wrote that you lost the case, you go, no, we actually won that case. He got a big judgment, and stop. That's okay under Colorado ethical practice. Not the majority rule. That's the minority rule. Going back, here's some tips to avoid violating 1.6. Going back to the 2 email rule, this is another aspect of it. If you reply to all on an email, you better know who all are. Because if the other side that sent you an email puts somebody incorrectly on that email chain, that's their screw up. But if you reply to all, you may just have violated Rule 1.6 because you may be sharing client information with somebody else. So for example, you've got a big piece of litigation with 5 5 parties and there's 15 lawyers and there's all those names. And if it's several different names at the same law firm, then that's fine. You're not disclosing anything because that law firm knows that information anyway. But especially with small companies, there'll be names that are, Gmail accounts or something. And if you don't know who that person is, do not reply to all, because the example might be the other side meant to copy their paralegal, but autocomplete put in the name of their brother-in-law instead, and they sent the email. Great, they just screwed up because they sent client information to their brother-in-law instead of their paralegal. But then when you reply to all, you just sent client information to their brother-in-law. So be careful when you reply to all. Don't leave work unattended in plain view. Don't discuss client matters in public places. There's a famous incident of this. I don't know if y'all remember or been long enough to remember when Continental filed bankruptcy in Colorado. It hit the papers before the pleadings were filed. It caused a kind of a crisis. People were selling stock. It was a big deal. And they tried to figure out how it became public before the pleadings were filed. And it was determined to be that an associate working on the case was at the airport on a payphone talking to his girlfriend about the Continental case. And he was next to somebody at another payphone who happened to be a newspaper reporter. And it hit the papers that Continental was filing bankruptcy. So be discreet in your conversations. By the way, and this especially goes for anything you put out something goes out into the Ethernet, into the interweb world, you're never getting it back, so be super careful about that. There's an ethical requirement that all soft documents, like a Word document, has to go through a metadata scrubber. In other states, they have different rules. In some states, it's considered unethical to look for metadata on a document you receive. That's not true in Colorado. So in Colorado, the way we solve that problem is say it's got to go through a metadata scrubber heading out. Okay, this is conflicts. We're down to Rule 1.7, and again, we don't. Oh, I'm sorry. Question. Yes.
How do you apply Rule 1.6 to law firm placing on their website a list of representative clients if they have not sought each individual client?
Then that's an ethical violation. I will say this. I got hired. I'm going to drop a name here, and I'll tell you the end of the story. I got hired a while ago when it was a bigger deal than when it was then a bigger deal than it is now, to represent Microsoft. And I've been representing Microsoft for like 2 weeks. And I called the in-house lawyer with the most expected phone call of all time. And I said to her, would it be okay if I listed you as a client? And oh, sure, because when Microsoft hired somebody, that's the next call they'd get is, can we tell everybody that we're Microsoft's lawyer? So yeah, if you've got on your website representative clients, you should have gotten permission from every one of those clients before you do it. Again, even if you represent them on litigation matters that's in the public record, that would be a 1.6 violation if you don't have client permission. Oh, okay, back to, 2 types of conflicts of interest, Rule 1.7. John, I can't believe you only give me 40 minutes to give this talk. You are nuts. We may not make it out of Rule 1. Okay, Rule 1.7, 2 types of conflicts, directly adverse conflicts and material limitation conflicts. A directly adverse conflict is exactly what it sounds like. You can't sue your own client. You can't sit across the negotiating table from your own client. A material limitation conflict is also exactly what it sounds like, which is that there is something that materially limits your ability to zealously represent your client. It might be the attorneys on the other side. It might be an issue that matters to you, that you care about. You want a particular result in the case. There's all kinds of stuff it could be. And what you've got to understand is that a material limitation conflict is just as real a conflict as a directly adverse conflict. If you're working on something and something in your brain is making you think anything other than what's in the best interest of the client here, if it's a material consideration, then that's a conflict of interest. I had a friend I clerked with that went to work for in the public defender's office in El Paso County, and she talked about their conflicts, because I asked her the usual question, like, how do you defend rapists? How do you defend, fraudsters. And she said, well, we've got a rule that you can always turn down any case. Any individual lawyer can turn down any case. And we've always had because somebody else in the office will take that kind of case. She said, we recently, and this would have been in the late 80s, we recently had a case, though, where nobody would take the case, and we had to hire outside conflicts counsel. Any thoughts as to what that case that nobody in the El Paso County Public Defender's Office would take? Nobody's ever, I've been asking this question for 30 years, nobody's ever gotten it. Poaching a bald eagle. Somebody poached a bald eagle and it went to the public defender, and nobody in the public defender's office would take the case because they all had material limitations conflict. They wanted the guy that poached the bald eagle to go to jail. So they had to send it out, and that's what you've got to do when you've got that kind of conflict. Conflict consents. Sometimes you'll hear people talk about conflict waivers. Again, that's old terminology. Current terminology is consent. They have to be in writing. They have to be confirmed in writing, which we talked about. They have to be based on informed consent, which we talked about. Advanced consents don't work. You see those engagement letters where somebody says, oh, by the way, if we get a conflict with so-and-so, we're going to represent them and not represent you, and you're okay with that. Those signed at the beginning of engagement, in my opinion, are not effective and enforceable because the client can't give informed consent on day one to a conflict that doesn't manifest until day 190. I don't think they work. So my advice is don't even try. We talked about, I mentioned in 1.8, 1.8 is business transactions with the client, and certainly getting a piece of any deal is covered. Also, payment of fees and anything other than hourly rates or contingency fee is covered. So if that happens, you have to advise the client in writing to have another lawyer look at the deal and give the client time to do so. There are cases where lawyers were deprived of all compensation, again, even though they went to the step of advising the client to have another lawyer look at the deal, but that advice was oral and not written. And they were denied all compensation because the court said it violated Rule 1.8. I think a payment plan, I think, would be okay. Well, it depends on I mean, if there's an interest component to it, that's probably a business transaction with a client or a promissory note. You'd say, have another lawyer, and again, all you got to do is say, have another lawyer look at this, send them an email, have another lawyer look at this, and wait a week. You can't make them have another lawyer look at it, but you got to give them time to do so, and you got to give them that advice in writing. Duties to former clients, you basically have the same duties to former clients as you do to current clients regarding confidentiality. You cannot use client information against a client, without client consent in the future. Even if it's an unrelated matter, you can't use client information against them. If something comes up on your conflicts check and it regards a prior client and an unrelated matter, not a conflict, you don't have to run a conflicts check. You don't tell either client about the situation. It's not a conflict, you don't talk about it if it's a prior client and an unrelated matter. Imputed conflicts of interest. Generally, if a lawyer at a firm is disqualified for one of these business reasons we're talking about, one of these conflicts we're talking about, a direct conflict to your client, whatever, the whole firm is disqualified. If it's a material limitation conflict, for example, somebody doesn't want to defend the bald eagle poacher, but somebody else is willing to do that, then it's okay. If the conflict with the public defender's office was that it's a public defender that was accused of the crime, that would disqualify the whole office. By the way, on imputed conflicts, often people put up what is now called a confidentiality wall or an ethics wall. Those don't always work. Those were designed for lawyers moving out of government practice into private practice. So if you think that applies, you got to read it closely. Because in Colorado, it says if the lawyer that moved personally and substantially worked on the matter, then the ethics wall doesn't work. So read that rule closely if that applies. If an ethics rule, if you think a confidentiality wall will work, put it in place. It's got to be timely, and the best way to be timely is to do it before the lawyer moves, before they start at the new firm, have that wall in place. Organization as the client, the obligation you have as a lawyer is to the client. It is to the organization, not to the individuals. If the organization is, if the constituent you deal with is violating their duties to the organization, or the organization itself is violating the law, you've got this duty to report up the ladder, they call it. This was something else that was tightened up after Enron. This rule was in the rules before, but there were a lot of excuses that gave the lawyer a way out to not have to report up the ladder when the client was engaged in, for example, criminal conduct. But they closed a lot of that weasel language up. And so now, generally, if the client's engaged in unlawful conduct and you're dealing with a low-level constituent, you've got to report up the ladder. If you get fired for reporting up the ladder, you got to report that up the ladder. Except in Texas, you don't. In Texas, you can go to the bar and have a drink. Dealing with a client with diminished capacity, this is becoming a more important rule as my constituent group is getting older. If your client you think is starting to have diminished capacity, if you have a reasonable belief that it's affecting what they do, then you may share client information enough to try to get the client help. And you've got to be like with a spouse, with a child, an adult child, with a doctor, but you need to be discreet and exercise discretion in who to talk to, because if you're worried that the client is diminished capacity because he keeps changing the will to leave the son out and put the son back in, take the son out, then you can't go talk to the son, right? You'd have to talk to somebody else about that. Okay, money in your trust fund. Don't ever let your trust fund go below zero. There's no excuses for this unless you get hacked and robbed. Don't move money out of your trust fund into your operating account, which is where you pay yourself, until you've actually earned it and done the work. When you finish a representation, you should send a letter saying, I'm no longer your lawyer. The file belongs to the client. If the client asks for a copy, you have to turn it over. You can keep a copy for yourself. In the days of electronic files, that's pretty easy. In the old days of photocopying, there was a tussle about who had to pay for the photocopies, and the answer is the lawyer, because the file belongs to the client. If you want to keep a copy of the file for your own protection, you pay for that copy. Duties to prospective clients. You owe most of the same duties to prospective clients regarding confidentiality that you owe to an existing client. And so before having even the briefest conversation with a prospective new client, say who's involved and run your conflicts check, like within the first minute, get the names. There are cases where a lawyer had a 10-minute conversation with a prospective client, then did the conflicts check, then found out the lawyer's partner represented the adverse party, and now that law firm is disqualified from the whole matter representing anybody after 10-minute introductory phone calls. So the first thing you do, tell me who the players are, who are the good guys, who are the bad guys, run your conflicts check, then call them back. How much time I got? Am I out? I think it said 3:10. Okay. You poor saps. You blame it on him. He said I could keep going. Okay, you can't delay a case just for the sake of delay, even if the client wants that. Candor to the tribunal. I'm glad we made it at least this far. This is one of the two rules where there's a mandatory disclosure of client information, even over the objection of the client. If your client's on the stand and lies to the court, you have to first remonstrate the client, which I did not know was a word until the ethics committee was working on this opinion. And what remonstrate means is you try to say, look, you got to go back on the stand and tell them the truth. You told them you were going 45 miles an hour and you were going 112, and you know it. If he or she won't back off, then you have to, and there's more steps to this, but in the interest of time, there's a formal opinion right on this point, and you should look at it. You have to tell the court that testimony of my client that he was going 45 was incorrect. You don't say what you think the truth is. and say he was really going 112, you say the testimony about him going 45 was incorrect, was false. This is one of the 2 times when you have to disclose client information over the objection of the client. You can't destroy evidence or prevent the other side from getting to evidence. You can't tell people other than your client or family members not to talk to the other side. Yeah, you know all this stuff. Don't try your case in the press. No, I'm going to start that. Lawyer as witness. This rule is actually a lot narrower than most people realize. It only applies to a lawyer at trial, to being a lawyer at trial, not in pretrial proceedings when the lawyer is likely to be a witness. And there's several exceptions, one of which is it'll be a substantial hardship to the client. So it can be like in a small case where at the last minute it turns out you might be a witness. It only disqualifies that lawyer from being a lawyer at trial, but other members of the firm can still represent the client at trial. So that rule is actually a little narrower than most people think. Okay, truthfulness to others. Generally, it's an ethical violation to be engaged in deceitful conduct anytime, 24/7. We'll talk about this if I get there in Rule 8.4. This is the one rule that kind of is an exception to that. It says you generally have to be truthful, but there's an exception if nobody's going to believe you anyway. So it's like when you're negotiating with the other side and you say, well, I think this is as high as my client will go, nobody believes that. So it's okay if it's not really true when you say it that way. But other than that, you got to be truthful all the time. Communication with the party represented by counsel. Okay, you can't do it. The trick here is it's on a matter-by-matter basis, and you got to know they're represented. Those are the two things on this rule. Even if you're dealing with somebody on their side that they have in-house lawyers, but if you don't know a lawyer is working on this matter, you can continue to deal with a layperson. Once you hear, however, that they've got a lawyer on this matter, you got to stop until that the lawyer says it's okay. You got to stop communicating with the client until the lawyer says it's okay. Yes.
You're dealing with somebody, they say, I've talked to my lawyer, they don't name their lawyer.
The question is, what if they say, well, I'm talking to my lawyer about this, you still got to stop. You say, I can't communicate with you anymore on this matter until your lawyer says it's okay. And then you always get to say, well, I'm thinking about getting a lawyer, right? They change their story and then you never know what to do. I hate that. Dealing with a represented person, dealing with an unrepresented person. So this is the hypothetical I give that we don't have time for, so it's going to cover both these rules. You're talking with somebody and they say, before we finalize this contract, I'm going to have to run it past my lawyer. You can keep talking to them because at that moment, you don't know that they've got a lawyer on this matter. They said they're going to have it in the future, but you don't know that they have it right now. But if they say, I was talking to my lawyer about this last week, now you got to stop until that lawyer says it's okay. If you receive a document that appears to be attorney-client privilege, your only obligation is to notify the sender. When I started practicing law, again, you'd get the call and say, oh, I sent that by mistake, would you destroy it? And the lawyer would generally say, yeah, you throw it in the shredder, and it's like no harm, no foul. And then everybody realized, wait a minute, the sending lawyer is the one that screwed up. If that document really helped the receiving lawyer's client, why is the receiving lawyer destroying that document that could be really helpful? So this rule kind of got changed, and to put the ethical conundrum on the sending lawyer that screwed up. If you receive it, your only obligation under the ethics rules is to notify the sender. If you're the sender that gets that call, then you try to get clawback right away, get to court, try to get an order depending on what was disclosed. Responsibilities of supervising lawyers. Basically, it's your obligation if you're at the partner level, at the supervisory lawyer level, to make sure your subordinate lawyers and support staff generally follow the rules of professional conduct, especially regarding confidentiality, again, Rule 1.6, regarding conflicts of interest, and having a confidential way to express complaints. Those 3 things every law firm should have in place, because that's your obligation as a supervisory lawyer. Figure out an ending. Are you talking to me now? Yeah. So I got to wrap up? Yeah. Is that what you're saying? Okay. I'm going to figure out an ending. Rule 6, pro bono work is still aspirational. I like that. Okay, I'm gonna compare, reporting two other things. Reporting misconduct. This is the other place where the rule trumps Rule 1.6. If you find out another lawyer, there's a mandatory grievance, which is usually they misuse client trust funds, they have a substance abuse problem, or they committed a serious crime, and it's a mandatory report. Even if you found out about it while representing a different client and the client says, no, don't report my other lawyer, don't do that, you still have to do it. This is the other rule besides 3.3 that trumps 1.6. And then finally, again, misconduct, your own criminal work, or your own criminal conduct is only also an ethical violation if it is what they used to call moral turpitude, if it reflects on your honesty, fitness, or trustworthiness. If the crime reflects on that, then that's also an ethical violation. If the crime doesn't reflect on that, then it's not in and of itself an ethical violation. You do have to be, I don't have time for this. Okay, and you gotta not engage in deceitful conduct 24/7. There are lawyers that have been disbarred for deceitful conduct that had nothing to do with the practice of law. The prohibition on deceitful conduct applies at all times. Okay. You're laughing at me. I think you guys get a break now. You lucky people.
Let's take 5.
Yeah, I just looked at it yesterday and said 40 minutes.
Hey, I told Jack Tanner ahead of time 40 minutes, and then being the moderator is sometimes a thankless job, but Jerry has made me appreciate that it's a great day to be alive, right? Jerry Pratt is back up here, and I invited him up. He and I have worked on an opinion that I think is interesting for a lot of lawyers in different contexts. Jerry has his own firm in the Denver area, and he has provided, I think, which is still in a draft stage of the opinion technically, or is it? Yeah, it's published now. And
It's published and it's in the materials.
yeah, see? And so, so he's going to go over the issues related to evidentiary issues when your client has evidence of wrongdoing and wants to call on you. And with that intro, please welcome Jerry Pratt.
Thanks. And John, thank you for being the moderator. You said it was thankless. It's not thankless. I'm happy to take questions as we go through this. Feel free to raise your hand, ask me questions. We can have a discussion. What are the ethical issues that arise when your client comes to you and wants to give you evidence that may incriminate the client or points out where evidence is that may incriminate the client? And John mentioned the ethics opinion. It's CBA Ethics Committee Opinion 60. Opinion 60 was initially adopted in Colorado in 1982. However, it was updated February 2025, just a couple months ago. The first thing you look at, say the client comes to you with the smoking gun. There was a murder, client comes to you, says, I want you to hold the gun. What you and I talk about is privileged. There's attorney-client privilege, there's the duty of confidentiality. I want you to hold the gun, or the knife, or the computer, or the cell phone. That's what Opinion 60 talks about. There were 6 fact patterns that were addressed in 1982. The Ethics Committee updated those 6 fact patterns and discussed the rules of professional conduct, which were adopted in 1993. In 82, the old Opinion 60 was based on the Code of Professional Responsibility. So the Ethics Committee updated the analysis of those 6 fact patterns and put in 4 new fact patterns based on technology that didn't exist in 1982. So the first thing you look at, first thing to consider, when a client comes to you with evidence that may incriminate the client. Rule 3.4a of the Rules of Professional Conduct says that a lawyer shall not unlawfully obstruct another party's access to evidence. A lawyer may not unlawfully alter, destroy, or conceal material having potential evidentiary value. And the lawyer cannot assist another person to do that. Comment 2 to Rule 3.4 says that if a lawyer has temporary possession of the incriminating evidence for a limited examination that will not alter or destroy the evidence, the law may require the lawyer to turn the evidence over to authorities. If you ever take possession of incriminating evidence, do not alter or destroy it or conceal it. There are criminal statutes. You could be prosecuted criminally in addition to the rules of professional conduct. CRS 18.8.610 deals with tampering with, concealing, altering or destroying physical evidence. If you do that in where the underlying criminal matter is a misdemeanor, the tampering is a Class 1 misdemeanor. If it's a felony case, the tampering is a Class 6 felony. In addition to the tampering statute, there's 18.8.105(2)(e), accessory to a crime. One way to be an accessory to a crime is to conceal, destroy, or alter physical evidence. And the offenses can be anywhere from a petty offense up to a Class 4 felony. So we mentioned Rule 3.4a. There's also Rule of Professional Conduct 8.4b. So it's professional misconduct for a lawyer to commit a criminal act, just cited those statutes, that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. Rule 1.2d. Say the client wants you to hold the physical evidence, but you're not willing to do that. So the client says, I have the knife, and I don't want to get caught with the knife. What do? Do not tell the client to go throw it in the lake, because that would be counseling a client or assisting a client in conduct you know to be criminal, destroying evidence of a crime. That's criminal conduct. We just saw the statutes. Don't counsel or assist the client on that. 1.2d, though, says that you may consult with the client and advise the client on what the applicable law is, and let the client make their own decision. So client, you have this knife that may have been used in this murder. You don't want to get caught with it, but don't give it to me. I'm not taking it. And you don't want to get caught with it. The law says if you destroy evidence, it's a crime. It can be a misdemeanor or a felony. Murder is a felony. That's the applicable law. But I can't tell you what to do with it. You let the client make up their own mind. We'll come back to this in a minute, taking temporary possession. I mentioned it previously, and we'll come back. Jack Tanner mentioned Rule 1.6, confidentiality. It's extremely broad. It's much broader than attorney-client privilege. Rule 1.6a says that a lawyer shall not reveal information relating to the representation. Unless, this is 1.6a, unless the client gives informed consent, it's impliedly authorized to carry out the representation or permitted by an exception to Rule 1.6a. So, could a client give informed consent for you to turn over the knife used in a crime? They could. In an example we'll see later, toward the end of the PowerPoint, if someone was murdered and they were slashed to pieces, and the client says, I'm being charged with murder, and I was in a fight with this guy, and I stabbed him, but here's the knife. It's my pocket knife. We got in a fight and he was going to shoot me, and I stabbed him first. Here's my pocket knife. There's no way I cut him to pieces with this knife. So I'm going to give it to you for you to turn it over to the authorities. That's one example where there could be informed consent. Impliedly authorized to carry out the representation, that's something like, I come to you and I say, I understand you were a witness to what took place. I'm Jerry Pratt. I represent the defendant. He's charged with assault. I understand you're a witness. I'd like to hear what you saw. I've revealed information relating to the representation. I've told you who my client is. My client's charged with assault. But that's necessary to carry out the representation. You can also reveal information if there's an exception under Rule 1.6b. One of those exceptions, 1.6b8, is you can reveal information to the extent necessary, that you reasonably believe necessary, to comply with law or a court order. So if the client brings you the gun and you now have possession of it, to avoid violating the criminal statutes by concealing the evidence, you have an obligation to turn it over to authorities. But how do I do that with Rule 1.6? 1.6b8 says I can do it to the extent I reasonably believe necessary to comply with the law. Reasonably necessary. I call it the drip from the faucet, not the bursting of the dam. You don't go to the authorities and say, I represent John Doe, and John Doe came to me and he told me this was the gun that was used in the murder, and now I have to give it to you. Here you go. You turn the evidence over to the authorities with Rule 1.6 confidentiality and also attorney-client privilege. You do not tell the authorities where you got it. You do not tell the authorities who your client is. You do not tell them anything your client told you. You simply turn it over to authorities. One thing to consider, and Opinion 60 says consider this. In that situation, consider hiring, retaining another lawyer to turn it over for you. You've now got another layer of confidentiality. One further step removed from revealing information about where the gun came from, who the client is, or anything the client said. I'm going to skip over this. If a client ever comes to you pointing out incriminating evidence or wanting you to take possession of it, Rule 1.4 of the Rules of Professional Conduct requires you consult with the client. You have to consult with the client regarding the means to achieve the client's objectives, any limitations on the lawyer's conduct. So you want to hire me as your lawyer, but I cannot violate the rules of professional conduct, and I will not do anything to violate the rules of professional conduct in representing you. I will not violate the criminal statutes by concealing evidence. And you explain this so the client can make an informed decision. They have the pocket knife that in no way matches up with the way the victim was murdered. They come to you with the pocket knife. You consult with them about it. You consult with them about the underlying charge. You consult about the crime of destroying or altering evidence or concealing evidence. You consult about your limitations as a lawyer. And what do they want to do? With all of that consultation, the client may say, here's my pocket knife. I want it turned over because it will prove I did not commit that murder. That's informed consent. Jack Tanner mentioned informed consent. It's defined in Rule 1.0e. It is an agreement to a proposed course of conduct, for example, turning over the knife, after the lawyer has communicated adequate information regarding the material risks and the reasonably available alternatives. So CBA Ethics Opinion 60, adopted in 1982, revised in February of this year. We'll go through each of the fact patterns. Fact pattern number 1, this was there in 1982, still there. Client asks you to hold confidentially the weapon used in a murder. What do? Think about Rule 1.6, confidentiality. You can't reveal that the client has asked you to do that. Attorney-client privilege. Same thing. You cannot reveal that. And I'm going to take a detour here for a quick minute. What if they're not an existing client? They're a prospective client. And they come to you with the incriminating evidence. And you say, well, they're not a client. Am I still restricted by confidentiality and the rules of professional conduct? Yes, you are. And I've cited two things here. Denver Tramway Company versus Owens. It's an old case, 1894. It's still good law. That says that attorney-client privilege applies even if they never use the term prospective client, but even if the prospective client never retained you to be their lawyer. The fact pattern in Denver Tramway versus Owens, and one reason I like to cite it is because it's kind of historically interesting. A lady was in downtown Denver, was getting off a streetcar, and she fell. She went to talk to a lawyer. She had never had him as a lawyer. She just went to talk to him to find out about a case against the tramway company. He spoke with her about it, and she never hired him. She later hired a different attorney, brought a lawsuit against the tramway company. The tramway company, as a defense, subpoenaed that first lawyer that she had gone to and wanted to know what she told him because they suspected it was different than what she was testifying to in court. And he refused to answer. And they said, well, she was never your client. She never retained you. She never paid you. There was never an agreement to represent her. She was not your client. And the court said, attorney-client privilege still applies. When a person goes to a lawyer seeking advice and the lawyer consents to speak with the person, attorney-client privilege applies. Colorado Rule of Professional Conduct 1.18 talks about prospective clients. And it says when a prospective client gives you information, that is confidential, just like Rule 1.6. So here, the client or prospective client has come to you with the knife, the gun, the poison, whatever the murder weapon may have been. Think about the criminal statutes. You do not want to alter, tamper with, or conceal it. And you do not want to be an accessory by helping to conceal it. There are the rules of professional conduct that apply. The best advice in Opinion 60, the best advice is do not take possession. Do not take possession. What if you end up taking possession? What if the client has an envelope, a large mailing envelope, hand-delivered to your office, and it's sitting on your desk with the gun in it? And you come back from lunch and say, oh, this is a great afternoon. Ideally, before taking possession, you advise the client on the limitations on what you can do and what you can't do, and your duty to turn it over to authorities. You advise the client and you follow through on this. In turning it over, you do not identify the client, you do not say where you got the gun, and you do not say anything that the client told you. Fact patterns 2 and 3 in Ethics Opinion 60. Somebody brings you the knife or the gun, the murder weapon, but it's not the client. It's the client's spouse or the client's friend. And they say, you know, my good friend asked me to bring this to you, and he wants you to hold it confidentially. Same analysis applies. You can't alter it or destroy it or conceal it. But the friend or the spouse is not a client or a prospective client. So even though you follow the same procedure, you advise the client of what the obligations are, not the spouse or the friend, because you don't want to be giving them legal advice, but you advise your client of your obligations. Again, you turn it over to authorities. You do not disclose where you got it or any of the circumstances. However, you could be compelled to reveal the source of that evidence because the spouse or the friend were not your client. Fact pattern 4. Client comes to you with several $100 bills, and there's been a robbery where you know $100 bills were taken. And you ask the client, did this come from the robbery? And the client says, what do you think? Same analysis. Best advice, do not take the money. But if for some reason you end up with the money, advise the client of your obligations, turn the money over to authorities, and do not reveal the client or information from the client. Fact pattern 5. The client doesn't give you anything, but the client points out where the body is located and where the getaway car in a robbery is located. And you go and you look and you see it. You don't touch it, you don't do anything with it, but you know where it is. Do not tell authorities. You have Rule 1.6, confidentiality. You have attorney-client privilege, and your obligation is to not reveal that information. Your observation is based on a client's communication, so attorney-client privilege comes in. Rule 1.6 governs information relating to the representation. So I think that both of those, both the rule and the attorney-client privilege apply. You do not tell authorities. What if, fact pattern 6, you have an investigator take scrapings from under the victim's fingernails? That might provide evidence of self-defense. That might be helpful to your client. Opinion 60 says that doing that does not violate Rule 3.4a because you're not obstructing anyone else's access to evidence. And this goes back to that comment to Rule 3.4a about if a lawyer takes temporary possession, you may have an obligation to turn the information over to authorities. So remember, you were told, you were pointed out where the body is, where the car is. You don't tell anybody. But now you're taking scrapings. You're changing it from its original state. If the prosecution or the police were to find the body, the scrapings have been altered, the fingernails have been altered. You must reveal that the scrapings were taken to the authorities. So before you do that, before you have your investigator go and take scrapings from the victim's fingernails, discuss it with your client and say, if we do this, we're going to have to reveal the fact to the authorities. It might really help you. It might help establish self-defense. On the other hand, it might not. So don't do that until you've consulted with your client and you've gotten the consent of your client to do it, knowing the alternatives and the material risks. These 6 fact patterns were all in original Ethics Opinion 60. Cell phone. This is a new fact pattern. Cell phones didn't exist in '82. Client is under investigation for fraud, investment fraud, and he buys a new cell phone. And he wants to know what to do with his old one. Remember Jack Tanner mentioned competence, Rule 1.1? You have an obligation to keep abreast of modern communication and other relevant technology. You know that that old cell phone may contain contact information, texts, emails, potential location device or location where you were at, where the client was at. So you may not advise the client to destroy or conceal the old phone. You cannot assist the client in doing it. The existence of the phone and the client's possession of it are still confidential. So you don't tell anybody. Fact pattern 8. Fact pattern 8, the client is charged with distributing illegal drugs using a car. And to pay your legal fees, the client wants to transfer ownership of the car to you. Again, under your obligation of competence, you need to be aware that modern cars may contain digital evidence. They may have information regarding the location of the car at different times, use of mobile apps through the car, cell phone usage through the car, videos that have been taken by a dash cam or the car's videos. And cars may transmit data to the manufacturer, so you need to be aware of that. Advise the client that if you were to accept the car, you may have to turn over that data to the authorities, or maybe even the car itself. There's another risk with that situation. If you were to take the car and use the car, you may be destroying evidence because you may be overwriting the digital data with new data. Transferring ownership information with the manufacturer may delete data from the car. So you need to be aware of that and make sure you don't inadvertently end up destroying evidence. If you were to accept the car, if you were willing to do that, you might consider using a forensic expert to create a forensic image of the data before you take possession. Fact pattern 9. This is a very tricky one. A lot of debate within the subcommittee on how to handle this. So the client comes to you and they have child pornography in photographs, video, and on their laptop. And they want advice on how they can hide it so other people don't see it, or if necessary, how do they destroy it? Under Colorado law, the mere possession of child pornography is a crime. The mere possession of it. The best advice is don't take it. But the client isn't asking you to take it. The client is asking, how do I hide it or how do I get rid of it? If there is a legal proceeding or investigation, Rule 3.4a prohibits advising the client on how to conceal or destroy the child pornography. Even if no legal proceeding or investigation is pending or can be foreseen, the mere possession is illegal. So if you advise the client to destroy it, you're violating Rule 1.2d, 8.4, Criminal Act. So what do? If the client keeps it, it's a crime. If the client destroys it, it's a crime. On the subcommittee, I thought you should be able to tell a client, possessing it is a crime, so stop committing the crime. You may be advising a client to commit another crime by destroying evidence. So what to me is very unsatisfactory, but the best conclusion we could come up with is discuss with the client the law, what the law is, keeping it as a crime, destroying it as a crime. Discuss the law, the application of the law with the client, say that's as far as I can go. And the client needs to make up their own mind what they want to do. Real quick, fact pattern 10. Client is charged with assault in a bar fight. The only evidence the prosecution has is the victim's statement. You talk to your client's friend who says, I was there and I saw what happened, and I have video. So they want to show you the video on their cell phone, and it shows your client beating the victim. You have no obligation to tell the prosecution of that witness. You have no obligation to tell the prosecution there's a video. But what if the friend, don't tell the friend to destroy it. That would be unethical. Don't hold the phone. Don't manipulate the phone, because that might be considered possession. And once you take possession, you have an obligation to notify authorities. Another thing we debated a lot is, what if the friend wants to send you a copy? They want to email you a copy. Are you then possessing it? And do you have an obligation to notify authorities? We said, no, you don't, as long as it's a copy. Because the prosecution, the police, still have the opportunity to do their own investigation, find the witness, look at the video on the witness's cell phone. It's risky if you take a copy, because if the friend destroys the video on their phone and tells the police, I gave a copy to Jerry, he's got a copy, potentially I could be compelled to produce it. So don't take it. Just don't take it. CBA Opinion 60 has some recommendations. Avoid taking or handling potential evidence. Instruct your staff, investigators, agents to not take physical evidence. If you must take it, advise the client on your obligations under the rules and your obligation to turn over incriminating evidence. Do not advise the client to destroy it or conceal it. Here are some cases real quick. State versus Allwell. The attorney's client gave him a knife. And there was a coroner's inquest. The attorney was subpoenaed to produce any and all knives he might have that related to two defendants. So the attorney responded to the subpoena. He showed up at the inquest, and he was asked, do you have any knives belonging to John Doe? He said, no, I do not. Do you have any knives related to Jane Smith? He says, I refuse to answer that question. And then he was asked, is the basis for your refusal to answer the question attorney-client privilege? And he said, I refuse to answer that question. The trial court found him in contempt. On appeal, the appellate court said attorney-client privilege overrode the subpoena, and he was correct in not answering those questions. People versus Belge. The defendant was charged with murder, and he spoke to his attorneys, and he told them about 3 other murders he committed. One of the attorneys went out and did his own investigation, and sure enough, found the body and did not tell authorities. Later, at trial, the defense for the defendant was insanity. And they called the defendant to testify, and he testified about the other murders he committed. There was a huge public outcry. How could these lawyers not have told the police when they saw the body? They knew where it was. And they were indicted by a grand jury for some obscure violations of some obscure statutes on respectful treatment of a dead body. The appellate court said that they were correct in not disclosing the location of the body because it was attorney-client privilege. They didn't touch the body, they didn't alter the body, they knew where it was, they didn't inform authorities. And they said that was the correct course of conduct. People versus Meredith. This comes into observing versus altering. So there were two defendants. It was a robbery and a murder. One defendant was charged with actually committing the murder, and the other defendant was charged with conspiracy and with robbery. The defendant charged with robbery and conspiracy had taken the victim's wallet, taken money out of the wallet, split it with the other defendant, and then tried to burn the wallet. And then he threw the partially burned wallet in the trash behind his apartment building. He told his attorney about this. The attorney had his investigator go look at the trash. Is there a burned wallet in the trash? Sure enough, there was. So the investigator took it out, brought it to the attorney, and the attorney turned it over to authorities. The court said that there was an obligation on the attorney's part to reveal where the wallet had been found, because the police could not inspect it in its original state, because it was taken out of the trash. If the lawyer had just observed it, or the investigator just observed it and left it alone, would not have had to say anything. But they altered it, so they had to reveal the location of it, in addition to just providing it. Swearingen is a Colorado case. Client was charged with forged documents, a deed of trust and a promissory note. He gave the originals to his attorney. His attorney showed them to the district attorney in a meeting, handed them to the district attorney. The district attorney kept them. Later at trial, the defense moved to suppress the original documents. And the court said neither attorney-client privilege nor the Fifth Amendment right against self-incrimination prohibited the DA from having those documents. A deed of trust is recorded with the clerk and recorder. The only way to enforce a promissory note is through court. So the defendant had no reasonable expectation of privacy. So there was no unlawful taking of those documents. But the attorney did the right thing by showing them to the district attorney. Quinones, we're going to skip over, it's in the materials. This is a cautionary tale, United States versus Russell. This goes to the child pornography. A choir master for a church in Connecticut had a laptop, and he gave it to a church employee to use for some church business. The church employee discovered there was child pornography on the laptop. So the employee went to the church officials. The church officials retained an attorney. The attorney, thinking it's illegal to possess child pornography, there's no case, did what I think you should be able to do. Quit committing the crime, destroyed the laptop with the child pornography. What he didn't know, and what the choir master didn't know, is the FBI had already begun an investigation. So the lawyer was charged with a violation of a federal statute for tampering with evidence. Could have gotten up to 20 years in federal prison. We don't know what an appellate court would have ruled, because the attorney accepted a plea agreement to a different charge, misprision. Misprision being failing to report the commission of a felony. So we don't know how it would have come out on appeal, but like I said, it's a cautionary tale. Because how do you know if there's a pending matter? How do you know if there's an investigation? Maybe you don't, but you do know your client has come to you asking about what to do with child pornography. So the unsatisfactory answer to me, but the best answer is, you tell the client what the law is. It's illegal to possess, it's illegal to destroy. Okay, I'm happy to answer questions. I know a little over time, but if you have any, I'm happy to answer. Yes? Yeah, so the question, the question is, it seems pretty clear that if you take possession, you have an obligation to disclose it to authorities. But what if it's inadvertent, where you come back from lunch and the client has put an envelope on your desk with the gun in it? Can you simply advise the client and give it back to the client? The answer to that is I don't really know. Maybe you can. I would say you're in a better position if you never open the envelope and you don't know what's in there, and you give it back to the client and say, I don't know what you're giving me, but I don't want it. Don't be dropping stuff off with me. We need to have a discussion first. Here you go. If you open it up and you look at it, do you touch it? Are you altering it? Are you changing the opportunity of the police to see it in its original condition because you're manipulating it somehow? I think your safer course is to say, I have to turn it over to authorities. And remember, when you do that, you don't say where you got it, and you don't reveal any communications from the client. It's the best I can come up with. Yes? I think you answered your question. Well, maybe, but you know, you didn't create the situation. So I'm sorry, I should repeat the question. So you get the gun or the knife, and it may have the client's fingerprints on it. And you shouldn't wipe the fingerprints off, shouldn't wipe the gun off, because now you're altering it. Now you're tampering with evidence. But if you turn it over, it may reveal who the client is because of the fingerprints. It might, but it's incriminating evidence. And you cannot alter, destroy, or conceal the evidence just because it's incriminating.
Thanks, Jerry. Our next speaker is Magistrate Clark. And she's been really involved in the access to justice efforts here in Larimer County. And she's sitting in courtroom 2B, and I'm like, how do I get a hold of Magistrate Clark? And it dawned on me to go into my contacts and call my office phone. And she answered. So I have her under my office phone, in my phone. But let's please welcome her, Magistrate Clark. I didn't say University of Akron.
That's good memory.
Is that in Ohio?
It is.
University of Akron. Akron?
Akron.
Akron.
All right.
The what?
The Zips. It's the mascot. It's a kangaroo. Good afternoon. I'm Kara Clark. I'm going to talk to you a little bit about access to justice. And I am going to respectfully disagree with one of the prior speakers who said that pro bono services are still, or pro bono work is still aspirational. It's not aspirational. It is an obligation that every lawyer has. Every lawyer has a professional responsibility to provide legal services to those unable to pay. And for more information on your professional responsibility, you can look at the Rules of Professional Conduct, Rule 6.1. The part of the rule that is aspirational is that each lawyer should aspire to provide 50 hours of pro bono public service per year. So the amount of service that you provide, the recommendation or the aspiration is 50 hours, but the obligation exists with each and every lawyer to provide services to those who are unable to afford to hire an attorney. And there are a lot of different ways that attorneys can fulfill this obligation. One is kind of the most obvious is taking a pro bono case, representing someone from the beginning, from the filing through the disposition of a case. That is one way that you can fulfill your obligation, but it is certainly not the only way. The Colorado Rules of Civil Procedure, Rule 11B, talks specifically about an attorney's ability to provide unbundled or limited representation to clients. Rule 11B allows an attorney to represent a client for a limited purpose. So, for example, a temporary orders hearing in a domestic relations case, a protection order in a domestic relations case. I have a domestic relations docket, so those are the ones that come to mind most readily. But if there is a specific issue that you want to help a person with, or that you feel, or they feel they really need the assistance, but you are not in a position to take on representation for the entire case, you can do those limited services. If you're going to enter into the case to represent a client in court, you are required to file a notice of limited entry of appearance, and the client does have to sign an agreement. The purpose behind that is you want to be very clear with the client, because it's easy to establish an attorney-client relationship. I think you guys have heard a lot about that this afternoon. So if you file an entry of appearance on a person, on a case, and you say, I'm only helping them with this issue, it needs to be really clear to everyone, including the court, that the client understands the limitations on the representation and that they consent to that. Once you are done with that limited representation, the attorney must file a notice of completion, and then you're automatically removed from the case. It's not a motion. You don't have to have permission from the court. It's an automatic under the statute. But it is important that you file that. One of the things that happens, I think, quite often is that people put in their notice, I am going to represent this person at this hearing on April 16th at 3 p.m. That hearing comes and goes, but the attorney never files that notice of completion. The way that our e-filing system works, when an attorney makes an entry of appearance, even on a limited basis, all of the pleadings then go to the attorney automatically. So you also, as a practitioner, need to make sure that you are aware of that, because if you're representing someone in a divorce and an attorney enters on a temporary orders hearing, you can only speak to the attorney about the temporary orders issue, or they only have to speak to you about that. That's the limitation. And so when you're serving them, you would serve them any of the documents related to your representation. So if you have witness lists, exhibit lists. But if there is an issue outside of the temporary orders, you have to update financial disclosures, or you're filing contempt, or there is something outside of that, it is your obligation as the attorney to make sure that the party who is pro se for all of the purposes except temporary orders gets that. So I tell you that to make sure you're fulfilling your obligation, to make sure people are getting what they need, and also to emphasize how important it is for you to file that certification of completion once you are done representing them, because otherwise you're getting the documents and they probably aren't. Unless people are specifically going in and adding them or mailing them, the court filings go to the attorneys rather than the clients. So that is an important step that I think gets missed more often than it should. Attorneys can also, under Rule 11B, assist with drafting of documents. So if someone comes in needing help with a motion that's more complex than just filling out a JDF form, you're able to help with that, and that counts. That can count towards pro bono services if you're doing that for someone for free. But it can be very helpful because oftentimes, especially when the other side is represented and someone gets a motion that is heavy on the law, that can be really difficult for people to respond to in an appropriate way. And as you all know, if you don't respond to a motion, it's deemed confessed, and that can really put a client in a bad position. If you are going to assist with drafting, you do need to put a Rule 11B disclosure on the document. You are required to let the court know that it was drafted with the assistance of an attorney, who that attorney is, their bar number, and contact information. You're not required to sign the pleadings, and you don't have to do any kind of independent research. So if someone comes to you and says, here's this motion I got, I need help with a response, or here's this issue, I need help with a motion, and here are the facts, you don't have an independent obligation to go out and investigate and make sure that what you're putting in that document is true. Now, if you have reason to believe or know that what they're saying is not true, that's a separate issue. But if it just turns out that what's in there is incorrect, untrue, you're not going to be on the hook for any of that. If someone comes and needs help filling out a JDF form, you don't have to. If there's a pre-printed form from the court, you're not required to disclose that you've assisted a client with that. One of the things that is important about Rule 11 is that it allows short-term legal assistance to self-represented parties on a pro bono basis, including but not limited to assistance through a nonprofit or court-sponsored program, and it does not create an expectation by either the client or the lawyer that legal assistance will continue. So there are a lot of opportunities through the Bar Association in Larimer County for you to provide legal assistance to people by answering questions for 15 or 30 minutes, depending on the event. That is incredibly helpful to the pro se litigant, and it really comes at no risk to you. There's not the risk that you, by virtue of having this consultation, are creating an attorney-client relationship. Now, there are separate issues as it relates to conflicts of interest and your ability to take on clients, the adverse party later on, but you don't, if a client comes and says, oh, I thought this person was my attorney because I met with them at Ask a Lawyer, Rule 11 is very clear that if you are doing that on a pro bono basis through a nonprofit or court-sponsored program, you're not their lawyer. I want to talk to you about the numbers to emphasize the importance of pro bono representation on a limited or a full representation basis. These numbers, these numbers are accurate for the 8th Judicial District through September of 2024. So for 2024, again through September, so the first 3 quarters, 1,698 domestic relations cases were filed. Of those cases, 1,110 cases had at least one party who was not represented by an attorney. In total, 73% of parties in domestic relations cases are unrepresented, and that's just here in the 8th Judicial District. For district court cases, 1,019 cases were filed, and 72 cases, at least one party had no attorney. In those cases, in district court civil filings, 36% of parties were unrepresented. In county court cases, there were 7,231 cases filed. 1,291 of those cases, at least one party had no attorney, and 60% of all parties in county court civil cases are unrepresented. What is more impressive to me, and these are also for the 8th Judicial District, I think these numbers are current as of March of 2025. Statewide, 20% of tenants in landlord-tenant cases and eviction cases, 20% of tenants are represented by counsel, compared to 92% of landlords. Here in the 8th, 98.4% of tenants are unrepresented in eviction cases, compared to landlords who are represented 88.5% of the time. So that is a huge disparity between representation, and there's good evidence that suggests that getting an attorney to a person who's facing eviction, the sooner in the process that can happen, the less likely they are to be evicted. And avoiding eviction is helpful both to the tenant, because obviously they are not being evicted, but it's also beneficial to the landlord to not have to go through the process. So getting tenants connected to attorneys sooner rather than later is really helpful. One of the things that is a volunteer opportunity that's coming up here in the 8th, they're beginning a mediation program for landlord-tenant cases where a third-party neutral mediator is going to get involved with the cases sooner rather than later to try to help the parties work together to avoid eviction. You don't have to know anything about landlord-tenant eviction law in order to volunteer and to provide a service and to benefit the clients. If you are interested in that and concerned because you don't practice civil litigation or you don't know anything about landlord-tenant law, Dan St. John will be giving you a free CLE. Yeah, so if you want to volunteer for that, there will be educational opportunities and mentors and people to whom you can turn if you have questions. And that's true not just of the landlord-tenant stuff. There are mentors available for people who are wanting to participate with pro bono programs, perhaps in a different area of the law or in an area of the law where you're not comfortable, but you know there is a significant amount of need. Practitioners who are experienced in these fields have volunteered through the Bar Association to be that mentor, to help out and answer questions. So not only is there that safety net, but if you're looking to expand your practice area, that is a really good way to do it. You're meeting your ethical obligation, you're providing service to the community members, and you're getting free mentoring, education, help. So it's win-win-win for everyone. We have some specific volunteer opportunities here in the 8th. One of them is the pro bono program through the Larimer County Bar Association. There are intakes with the program every Wednesday at the Justice Center and the last Tuesday of the month in Loveland at the court. I think it's at the courthouse. But we're always looking for volunteers for that program. There are a number of ways that you can volunteer. At those intakes, people who are looking for free legal services have an opportunity to meet with an attorney. It's an opportunity for them to get some advice, or in appropriate situations, for them to get some representation, either for the entirety of the case or on that limited basis. The pro bono program has been active in Larimer County for a long time, and there is a small but mighty group of attorneys who participate and who consistently volunteer for the intakes and who are the go-tos when there is a case where it is appropriate for further representation. Many of those go-to attorneys are nearing retirement or are wishing to retire. And so there is a big need for people to volunteer in that capacity. And again, with all of this, the amount of service that you provide is up to you. You can provide as little as a 15-minute consultation at the courthouse. If you want to be on a list to give additional services, doing a 1-hour consultation or meeting with a client on a semi-regular basis. If the case is compelling and you have the resources and the time, you can certainly provide full representation. If you choose to participate in the pro bono program and you represent a person either on a limited or a full representation basis, the Bar Association has malpractice insurance, and you are covered under the malpractice insurance. So if there are issues, that doesn't fall on your liability insurance. That would be covered by the bar. There are also events that the Access to Justice Committee does annually. So in April, coming up April 25th, that's next Friday, there's Family Law Day. That is an opportunity for people to come in, and there are classes on different areas of family law. And then we have Ask a Lawyer opportunities as well. We still need volunteers for that for next Friday. You can volunteer in chunks of time. If you are available, I have a QR code that you can scan, or I can give you the appropriate email addresses for you to get in touch with the right people. There's Ask a Lawyer Day in October, and that is an opportunity for people to come in and ask a lawyer. We need all areas of the law except criminal law. The Access to Justice Committee and the pro bono program don't get involved with criminal cases, but people come in and ask about probate and domestic relations and adoption and dependency and neglect and landlord-tenant and small claims. So all types of questions come in on those days. People can sign up for a 30-minute consultation. The committee also puts on a Senior Law Day that typically happens in August and September. There are classes that people go to learn about some of the different areas with probate and aging and Medicaid, and also Ask a Lawyer programs. So if you're interested in teaching a class, or you think there's a topic that would be helpful, those are opportunities for you to serve, and that counts towards your obligation to provide pro bono services. The newest thing that the Access to Justice Committee is doing, and we are looking for volunteers, is to start we are beginning a protection order clinic. Those will be every other Thursday from 12 to 1 at the courthouse. Many of you know that there was a really unique service in Fort Collins called Bringing Justice Home. That was a program that represented victim survivors of domestic violence in civil cases free of charge. That program closed in January of 2024, and it left a huge hole in the need for additional volunteers to help victim survivors of domestic violence. This protection order clinic is certainly not going to fill the void that was left by the shutdown of Bringing Justice Home, but it's one way that we are working towards filling some of those needs. One of the biggest goals of the Access to Justice program is to provide services to people who are traditionally underrepresented, and certainly anybody who cannot afford an attorney, people who are struggling financially are traditionally underrepresented in these cases because, let's face it, attorneys are expensive. But when you have a situation where there are protection orders, particularly in a domestic violence or an intimate relationship situation, you have not only a person who may be experiencing poverty, who may be temporarily unhoused or may be unhoused on a long-term basis, but there is an incredible disparity in power. And so people who are in that situation, who are going to the court and filing a protection order, that in and of itself is a huge and incredibly brave step for that person. And then to think about going into a courtroom and trying to represent yourself when your abuser is sitting over there and maybe they have an attorney, maybe they don't, but either way, going into a courtroom in that adversarial setting and talking about all of the bad things that that person did to you can be really intimidating. And I can tell you, people don't know how to present evidence in court. And the court is bound by the rules of evidence. So even if there's something that people really want you to see, if it's not admissible, it's not admissible. And having, even just getting some coaching beforehand of, this is how you lay foundation, or this is what the judge can consider, or, you know, that letter is going to be really helpful, except you can't have a letter, so have that person come in and testify. Knowing that beforehand is going to be very advantageous to people in these types of settings. Because one of the worst things that can happen is that a person does not meet their burden, and they have now told publicly all of these bad things and the things that they're scared of and the reasons that they asked for the protection order. And now they know everything. And you leave without a protection order, and that can put the other person in a really unsafe situation. So if people have the benefit, if people in a protection order setting have the benefit of legal counsel, either in the courtroom or just in preparation for the hearing, that can make a huge difference in their lives. So what if you can't volunteer? What if you're a government attorney or you work for a nonprofit and because of conflicts, you're not allowed to come and provide legal advice? There are still opportunities for you to volunteer and to fulfill your obligation to provide those pro bono services to the community. Working on committees is a way that you are providing legal services to those in the community who cannot otherwise afford to hire an attorney. There is a lot of work that goes into the logistics of these events, between getting speakers, thinking up the topics, getting rooms and brochures and advertising and food. A lot of work goes into that, and there's always room on those committees. So if you have, if there are reasons that you cannot provide those services, or maybe you just don't want to, you want to help out, but you don't want to be giving legal information to clients, you can ask, or you can join a committee and provide those services in that way. Also, one of the benefits to you of providing pro bono services is that if you do that through the pro bono program with the Bar Association, you can be eligible for CLE credits. Similarly, if you agree to mentor a person who is taking a pro bono case under the pro bono program with the Bar Association, you may qualify for CLE credit. The rules on that are a little bit different, but there are opportunities for you to get CLE credit while also doing the things that fulfilling that pro bono obligation. And in case you had questions about the impact of these services in our community, in 2024, at the Ask a Lawyer Day, 44 clients were served. At Family Law Day, there were 39 clients served, and at Senior Law Day, more than 100 people showed up to the event and were provided information and resources about probate and other hot topics in senior law. There's a monthly Ask a Lawyer clinic through the Self-Help Center at the courthouse, and approximately 144 clients were served in 2024. Through the pro bono committee with the Bar Association, there were 6 people who had extended legal services, so full representation or representation in the case on an ongoing basis. But there were 472 people in 2024 who were provided brief advice or brief legal services. So the impact that you can make by volunteering is huge. And with the pro bono program, there are requirements that the people who come and seek services qualify that they are indigent. So that's a way that you know that you really are helping people who are traditionally underserved and who are facing more barriers to accessing the legal system than maybe your average Joe. With other events, there aren't those requirements to prove that there are any financial issues or that you can't afford a lawyer. But if you want to make sure that you are really impacting people in the community who otherwise truly wouldn't have access to legal services, volunteering through the pro bono program is the way to go. And we are always looking for volunteers. And if you have ideas, if you are practicing and you see areas where there is great need, bring that to the Bar Association, bring that to the Access to Justice Committee. One of the projects that we're working on right now is a legal resource night. We have all of these events that occur at the Justice Center. And there are many reasons that people, particularly people who are undocumented or who don't speak English as their primary language, don't want to come to the courthouse. That's not a safe place for them. So one of the things that the committee is working on right now is to plan a legal resource night in the community where we're looking at churches, event centers, places where people may feel safer going and will then be able to access those legal services, those resources. We will have interpreters available. We're looking at doing some after hours programs for people who are working, and coming to an event in the middle of the day may also be a challenge because they're already facing financial hardship. So there are always opportunities for new projects if you see needs that are being unmet in the community. Thank you.
Thank you very much. We have an award that has been around now since, I believe, 1990, which is when it started. And I would like to get Lindsay Steele Item up here if she has a minute. Please.
Good afternoon, everyone. As Magistrate Jostad said, I'm Lindsay Steele Item, and I'm very honored to be presenting the 2025 recipient of the LCBA Professionalism Award this afternoon, because in my personal opinion, nobody better exemplifies the principles of professionalism than this individual. And while Magistrate Jostad suggested that I only take a minute, and I've already been preemptively admonished by the recipient that I should only take a couple seconds, I do feel compelled to just bring you back to how I first met this individual 15 years ago. It was a chilly March morning in the Larimer County Justice Center's jury assembly room upstairs, spring term day of 2010. I was new to Colorado after practicing for a few years in the Bay Area, and you may recall back in those days, California transports still spoke in hushed tones about their origins. I'd just taken the February bar and was to be introduced by this Roger Clark fellow. Needless to say, I was extremely nervous, and because I didn't then know how friendly and welcoming you'd all turn out to be. Much to my surprise and delight, I learned that one of the other new lawyers that was being introduced had also graduated from my law school, UC Hastings College of the Law in San Francisco, albeit a few years earlier. I chatted it up with this individual at the morning meeting afterwards and was instantly captivated by this extraordinary individual with a level of humor, fashion, smarts, and modesty that isn't routinely found in the legal profession. I learned that Candace Bradner Majoris was born in Seattle, Washington, and grew up on the West Coast. After she graduated high school, she spent a year studying abroad in Japan and went on to earn her Bachelor of Arts degree in finance at the University of Washington. I learned how prior to law school, Candace had accumulated an incredible wealth of life experience performing an insane variety of cool jobs, which included working summers at an oil terminal in Seattle, doing door-to-door sales, retail buying, serving as a tour director of the Western Canadian Rockies, bartending in an Alaskan ski area, and other unusual, impressive gigs I've been instructed not to mention, but may provide clues about if you hang out for the cocktail hour afterwards. Candace then attended UC Hastings College of the Law, where she served as Associate Managing Editor of the Hastings Law Journal. After graduating in 1991, Candace spent the next 15 years practicing employment law in large firms in the Bay Area, as well as in Phoenix, Arizona, including Bryan Cave LLP and Brown & Bain, which later merged with Perkins Coie, where she became partner. While practicing in Phoenix, Candace also volunteered for and served on the boards of the Arizona chapter of the National Multiple Sclerosis Society, as well as the Northside Training Center, a nonprofit group that provided educational training for disadvantaged individuals. In 2003, Candace and her husband Matthew welcomed twin boys, Sam and Andy. And I should mention Matthew and Andy are here with us this afternoon. Thank you both for being here. After a few years of somehow juggling being a partner at a big law firm and the mother of young twin boys, Candace and Matthew sought a better quality of life and conducted a nationwide search to identify the best place to raise their family. They ultimately settled on Fort Collins, moving in the fall of 2006. She'd expressed feeling fortunate to be able to take a few years away from the law to spend with her boys before they started kindergarten, and still stayed busy volunteering as a driver for Saints and serving as president of her HOA. After apparently missing the reciprocity deadline by 2 weeks, Candace took yet a third bar exam, becoming licensed to practice in Colorado in 2009. That brought her to where my story began when I first met her at spring term day. So after the morning meeting, we continued our conversation and made plans to join the bowling festivities that afternoon. Candace had been assigned to Magistrate Jostad's bowling team, which would mark the start of a spring term day tradition in the years that followed. Coincidentally, Candace had already been planning on contacting Magistrate Jostad about interning in his courtroom since she was wanting to gain exposure to state court and specifically family law matters, as she'd been relatively siloed off in federal court on account of her employment law practice. Some would have preferred the protective silo, but fortunately for our local community, this was not the case with Candace. So over bowling, they sealed the deal, and Candace would spend the next several months volunteering in Magistrate Jostad's 2B post-decree domestic relations courtroom. Talk about baptism by fire. Pun intended. During those months, Candace and I continued getting along famously and began making plans to launch our own firm together. By September of 2010, we had opened Majoris Steel Item LLC, and as Candace and I had only worked in larger firms and had never practiced family law and all the fun that comes with that, we often found ourselves with a lot of questions. And I know I speak for both of us when I say we'll always be grateful to you all for being so welcoming, helpful, and supportive of us during this time. Candace continued working on employment matters, and also we offered mediation services. These were definitely some crazy and exciting times, and I felt very fortunate to work closely with and learn so much from one of the most principled, talented, and scrupulous lawyers I've ever met. I cannot, oh, my apologies. See, I was trying to furiously excise big portions from my speech, so it might not be in sequential order here. Candace was always eager, dedicated, and hardworking in giving her very best for every single client, no matter their station or means. She was always a champion of the underdog, as many of her clients were of modest means, facing extremely challenging circumstances in their lives. She treated each of them just as I imagined she treated even the most prestigious corporate clients during her time in big law, if not with more attention, respect, and earnestness. No matter the caseload, no matter the pressures in her personal life, or her full plate of volunteerism, I never saw a scintilla of sloppiness or anything remotely half-baked in Candace's work. Even as the mother of young children and this hefty volunteer load, she would pull all-nighters to ensure an emergency protection order was promptly filed and zealously pursued, even if it remained unclear whether or not she would ever be paid, because it was the right thing to do for the client. Her clients were fiercely loyal to her and always deeply grateful. I'll forever be grateful for these special years practicing with Candace. But unlike Candace, who really did have an innate gift for the critical counselor at law component of family law, the practice of domestic relations was a bit of a struggle for me, and I wanted to learn other areas. So while we parted ways as business partners in 2014, we remained great friends. Candace would continue her family law and employment practice in the years that followed, and during this time also joined Celeste Kling as a co-instructor of the Families in the Legal Environment upper course in the Human Development and Family Studies Department at CSU for the next 6 years. In her letter to the committee in support of Candace's nomination, Celeste, in part, wrote, "Candace is one of the people I most admire and respect in the world. She listens, she thinks, she evaluates, she responds. She explains patiently, kindly, clearly, and with compassion. She's willing to make a tough call. She treads with concern at causing pain, yet she does not flinch at honoring truth and justice. In 2014, I sought out Candace as my co-instructor because of her love of the law, of young people, and her dedication to public education. She jumped at the opportunity to participate in that virtually pro bono outreach project and excelled in the classroom as a teacher and as an emissary of the very best of our profession. Getting to know her better and being able to observe Candace in action at close range increased my respect and admiration for her top-notch professionalism in whatever she does." End quote. I would note that as the esteemed 2010 Professionalism Award recipient, indeed Celeste Kling can be said to know a thing or two about professionalism. During this time, Candace continued to be an active and highly visible member of our local bar, whether it was reliably attending women's bar summer socials, reliably scoring mock trial tournaments, serving as a volunteer mediator. She also served in leadership on the LCBA Executive Board. In 2018, she began the final chapter of her legal career, being appointed to the bench as District Court Magistrate in the 8th Judicial District. Candace started out with the courtroom 1A docket, which included studying bonds, dispositions of certain misdemeanors, contempt, emergency motions, civil protection motions, and she later transferred to the 1B docket, which was comprised of post-decree domestic relations, protection orders, and emergency contempt motions. She also chaired the DR Best Practices Committee with Magistrate Christiansen. In 2018, she also began chairing the Access to Justice Committee, which, as we know from Magistrate Clark's remarks, aims to expand access to justice to community members who face barriers and are often low income in accessing the local civil justice system. Candace continued this hugely important leadership role until her retirement this last summer. During Candace's retirement ceremony, I recall the powerful way in which District Court Judge Lori Dean spoke about her colleague on the bench, beginning by the words, beginning by describing Candace as being the smartest person in the room. A sentiment that is widely shared, I'm sure. I also generally remember her discussing, similar to the remarks I made earlier, just that although Candace came from a background with, some pretty impressive clients, you would never know by speaking to her. And it didn't matter who came before her in her courtroom, whether they were, the pro se client or, the big lawyered up Denver peeps. She had the same, she invariably demonstrated the same high level of dedication, care, skill, and preparation, no matter what the case was. In her comments to the committee in support of Candace's nomination, Judge Dean wrote, "There are 3 things that strike me about Candace as exceptional. First, her work ethic was unparalleled. She was committed to her cases and would work tirelessly to get the answer right. It didn't matter what the issue was. She would drill down to the very heart of the case. Second, she exhibits the highest commitment to service." And then Judge Dean went on to cite the many examples I've already listed. Finally, Judge Dean concluded, "Her demeanor is excellent. She treats everyone with kindness and is inscrutably fair." I also recall Judge Dean's discussion of the local bench's fantasy football league and how Candace's utter domination thereof was also reportedly executed with the highest degree of professionalism. Although Candace retired from the legal profession last summer, she is still technically an active member of the bar, and it's my understanding she's happy to be gaining these ethics credits. She is just as active and passionate about her service to others as she was during her career. She volunteers for the Larimer County Food Bank, she travels to rebuild homes in hurricane devastation areas, and she serves as a SAVA sexual assault team member for middle and high school age students. As I hope I have helped illuminate in these remarks, in so many ways, Candace not only represents the best of us within our profession, but also as a model citizen within our community. For the aforementioned reasons, it is an honor and a privilege to announce the recipient of the 2025 Professionalism Award to Candace Bradner Majoris.
Lindsay. I asked her to be extremely brief. I should have known after 15 years. She ignored me. But I do thank you ever so much for this award. I am honored and humbled to receive it. As Lindsay can tell you, I was extremely surprised, but I'm very, very appreciative. I am very lucky, as she described, to have had a long and rewarding career in the law. I've practiced in 3 states. The 3 bars I could have done without, but I've been fortunate to work with wonderful people all along the way. I can tell you we are very lucky to practice here in Larimer County. Our bar is collegial, supportive, and full of skillful lawyers. On the issue of collegiality, I'm going to put in a quick plug for the Larimer County Bar Association and attendance at term days. It is a great way to get to know people, find out what's going on in the local bar, and then find out about the numerous volunteer opportunities that we have. Right, Dan? Okay. There are many people who have had an impact on my legal career, for whom I will always be grateful. But I do want to take a minute to thank a few people who have truly changed the course of my life. First of all, my family. Matthew, please stop filming this. And my son, who are standing over there. And then my son, Sam, who is in Oregon. They are the love of my life. And I couldn't have done any of this without them. They are loving, they are encouraging, they are supportive. You all know what unpredictable lives we can have with the law, and they have weathered it all. I also want to thank Magistrate Jostad, who gave me my first glimpse of the domestic relations world, and the entire professionalism committee. They work so hard every year to put this seminar on to bring the ethics issues before you. I, of course, want to thank Lindsay. She was my business partner for several years. She will be my friend for life. And anyone who knows her knows that she is an engaging, intelligent, and incredibly vibrant person. I also want to extend a very warm thank you to Celeste Kling. As Lindsay mentioned, we co-taught a course at CSU for 3 years, and her wisdom and caring are beyond measure. Finally, I want to thank the judicial officers of the 8th. They are, although you may differ at times, they are truly smart, funny, and thoughtful people. I was so proud to be one of their colleagues for 6 years. I particularly want to thank Magistrate Connors and Judge Dean, who generously shared their wisdom, their insights, and both have fabulous senses of humor that made certain days much better. I truly appreciated everything that they could share with me. I also want to recognize the people who work with the Access to Justice program, including, as you've heard from today, Magistrate Clark, Samantha Walsh, and Ian Bonner. As you've heard, it is an incredibly important program. I can't overstate that, as well as the importance of volunteering in our community. We have such need here, truly such need. And I hope you would consider lending your time, your talent, or your treasure to support those causes or programs that you hold near and dear to your heart. Finally, and given that this is a professionalism seminar, I'd like to take a moment to talk about our profession, where it is at this moment in time, and our role as professionals. As Lindsay mentioned, I was working with Brown and Bain in Phoenix, which later merged with Perkins Coie, and I was a partner with Perkins Coie. I must say that I've never been more proud of Perkins Coie than I have been in the last 6 weeks or so. I feel compelled to include in my remarks today some discussion of what my former firm has been going through of late and the ethical issues it raises for all attorneys. This is not, I repeat, not a political statement. This is a nonpartisan American issue. To briefly recap what has occurred in the last month or so, and as I'm sure most of you, if not all of you, have heard, an executive order was issued by the administration on March 6th that stripped the clearances, the security clearances of Perkins Coie lawyers, barred federal agencies from hiring employees of the firm, and prohibited the firm's employees from accessing federal government buildings. It was also aimed at terminating any federal contracts with the firm or entities that Perkins Coie represents. In response, the firm filed a brief which argued numerous constitutional violations of the order and said in part, and I'm going to use some quotes here, but I think the language and the ideas expressed in those quotes is crucial. And here's what part of the brief said, quote, "The order is an affront to the Constitution and our adversarial system of justice. Its plain purpose is to bully those who advocate points of view that the president perceives as adverse to the views of his administration, whether those views are presented on behalf of paying or pro bono clients. Perkins Coie brings this case reluctantly. The firm is comprised of lawyers who advocate for clients. Its attorneys and employees are not activists or partisans. But Perkins Coie's ability to represent the interests of its clients and its ability to operate as a legal services business at all are under direct and imminent threat. Perkins Coie cannot allow its clients to be bullied. The firm is committed to a resolute defense of the law without regard to party or ideology, and therefore brings this lawsuit to declare the order unlawful and to enjoin its implementation," unquote. The brief went on to state whatever short-term advantage an administration may gain from exercising power in this way, the rule of law cannot long endure in the climate of fear that such actions create, unquote. The nonpartisan nature of this issue was exemplified by an amicus brief that was filed in support of Perkins Coie and was signed by more than 500 law firms and 300 former judges. Importantly, that brief noted that the signatories' views on political and social issues vary, and argued that advocating for clients with candor and zeal is an indispensable element of the law. The judge hearing the case did grant a temporary restraining order, which prevented the administration from barring Perkins Coie employees from entering federal government buildings, and government contractors are not required to disclose if they do business with the firm. The judge did not mince words in her order, stating that, quote, "I am sure that many in the legal profession are watching in horror at what Perkins Coie is going through here. The order casts a chilling harm of blizzard proportions across the legal profession," unquote. I raise this issue before you today to advocate for the defense of the rule of law, our judicial system, and the very foundations of our profession. We all took an oath upon admission to practice law in this state, in which we swore to support the constitutions of the United States and the state of Colorado, that we would use our knowledge of the law for the betterment of society and the improvement of the legal system, that we would never reject for any consideration personal to ourselves the cause of the defenseless or oppressed, and that we would at all times faithfully and diligently adhere to the Colorado rules of professional conduct. These tenets I just mentioned are embodied within the rules of professional conduct. In fact, the preamble specifically refers to a lawyer's duty to uphold legal process and to further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. It also refers to the lawyer's obligation zealously to protect and pursue a client's legitimate interests within the bounds of the law. It also includes language that goes directly to the issue faced by Perkins Coie right now, saying that, quote, "An independent legal profession is an important force in preserving government under law, for abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for the right to practice," unquote. It's hard to dispute that lawyers and judges are under attack now like never before, just for doing your jobs. I attended the Speak Up for Justice webinar yesterday that featured the Dean of Berkeley Law School, Erwin Sherwinski, and a number of retired and current judges, one of whom was District Court Judge Esther Salas. You may remember that in 2020, it was Judge Salas's son who was murdered when he opened their home's front door to a gunman, a supposed FedEx delivery person who in actuality was an attorney who did not like the way his mother handled a case that he argued before her. Recently, like as in right now, pizzas are being delivered to the homes of hundreds of judges. The clear message being, I know where you live. And pizzas are being delivered to the homes of the judges' children, sending the same message. I know where your children live. Even more chilling, the name of the person supposedly sending a number of these pizzas has been that of Judge Salas's dead son. I realize that these somber remarks are certainly more somber than would normally be a part of this type of speech. But I felt that I had to speak up. I am passionate about the rule of law. It's been the profession of my entire life. And I believe that the rule of law obviously has a vital, absolutely essential place in our government and society, and I continue to believe that our legal profession is an honorable one. I know that our lives can be so hectic, but I hope you will take the time to reflect on the ethical and societal obligations that go along with being a lawyer. And if you feel strongly, I sincerely hope that you will not be afraid to stand up and speak up. Now, I didn't talk with Magistrate Jostad beforehand. I don't know if you get additional ethics credits for this. But
They'll take them away.
no, I thank you for your indulgence. I thank you ever so much for this professionalism award thank you, Lindsay, for your incredibly kind comments. This means more to me than I can say. Thank you.
Usually they're setting this up over here. Thanks for coming. We'll be back next year. Maybe a Tom McComb Memorial drink ticket. And I guess the CLE information has been sent to you all. If there's a question about that, just bug Bill over here. He'll help you. Thank you all. Good job.
Thank you. Sorry I spilled water right here. Whoops.